this petition.
Bit louder.
I'm praying for listening this next week. Monday.
Motion.
No, my admission.
Give it to the court martial.
May I please, Your Lordship, with the consent of other side, Lordship, I beg to mention item number 9. Here, Lordship, I have received the instruction. I'm filing my affidavit within 2 weeks, Lordship. Within 2 weeks, I have taken the consent. Yes.
You have received instruction.
Yes.
Okay, who is for the
Please, Your
petition?
Lordship, I beg to mention item number
1 minute.
4.
1 minute.
Yes.
Who is for the petitioner?
NN Chaudhary.
Okay,
I
you
have
have
taken.
informed.
taken. Yes.
Mr. S.S. Roy, Learned Central Government Council. For the respondents. Any private respondent? No.
No, Lordship.
For the respondents. Has submitted that he has received the necessary instructions to file the counter affidavit and has thus paid for listing of the case after 2 weeks in order to file the counter affidavit before or before 2 weeks. Full stop. It is submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. Post of the prayer is allowed, lays the case on suspension.
May I
Lordship.
please, Your Lordship? With consent to the other side, Lordship, I beg to mention item number 4 of the list.
4.
Yes, Lordship.
You are for the petitioner,
Petitioner,
Mr.
A. Borua, Lordship.
A. Borua, the learned counsel for the petitioner has made a prayer for adjournment of the case. Post of it is committed that he has the prayer is made with the consent of the learned counsel for the respondent. And the mention memo to that effect has also been
Okay,
circulated
Lordship.
yesterday.
Kindly fix that date.
Post of
Lordship.
as sought for and agreed to by the learned counsel for the parties, lays the case on after 4 weeks.
24. Lordship, may kindly fix on 24th, Lordship, if Lordship, that Lord.
24?
24th of March, Lord.
24, no. Maybe.
25th, Lordship.
But-
March of March.
Lordship, I'd like to mention item number 5 and 6. Here I am required to obtain some instruction from the Deputy Commissioner Dhuvri and DC South Salmara. They have sought for some more time.
How much time?
I prefer 4 weeks time.
Okay, who is for the petitioner? Mr. B.
petition-
Rahman, learned counsel for the petitioner is present. Mr. D. Nath, learned senior government advocate. Assam has submitted that he is awaiting some more instructions in the matter and has prayed for listing of the cases after 4 weeks. Post of the prayer is allowed, raise the cases on so and so.
Lordship. One, Lordship.
May I please, Your Lordship, with the consent of the respondent, I beg to mention item number 15, Lordship.
15.
Yes, Lordship. In this case, what happened, Lordship? Mediator returned a brief, Lordship, because mediator, Lordship, the process is mediation is going on.
Okay.
But mediator returned a brief because he got a government job. So he did not continue the mediation. So, but there is possibility settlement, possibility
Some
here, Lordship.
15 to some.
Mediator Amarendra Gogoi, Lordship.
Mr.
P. Sharma, Lordship.
P. Sharma, learned counsel for the petitioner, Miss
F. Shaheen on
F.
F. Shaheen on behalf of BK Sen.
F.
Correspondent number
Shaheen,
1.
on behalf of Mr.
BK Sen.
BK Sen. Learned counsel for the respondent number 1 are present. Full stop. There was the report. Here is a report of the Secretary, Gauhati, report dated 20/02/2026 of the Secretary, Gauhati High Court Mediation Center and the office note dated 23 2026. First of all. Para, the learned counsel for the parties have submitted that there is scope for mediation, further scope of mediation, further scope for mediation and consequent settlement. First of, in view of the same, the coordinator secretary and the Gauhati High Court Mediation Center shall appoint a new mediator to mediator. First of the parties shall appear before the Gauhati High Court Mediation Center on 10/3/2026.
We appear on 10th.
Yes, you appear on 10/3
Yes, sir.
to obtain further instruction in the matter. The case is to be listed after completion of the mediation process.
Daily list for motion, item 1. That's it. Our grievance has been redressed.
Redressed. Heard Mr. R.K. Sharma, learned counsel for the petition, and Ms. D.S. Neo, learned standing counsel from our irrigation department for all the respondents. First of, para, the learned counsel for the parties have made further submission in continuation of the order dated 23/2/2026. First of, para, Mr. Sharma, learned counsel for the petitioner, has submitted that the petitioner's grievance as regards site visit certificate has been redressed and the petitioner is in receipt of the requisite site visit certificate. First of, in such view of the matter, Mr. Sharma has submitted that in such view of the matter, the petitioner, the petition can be closed, right? You file your bid. We are not interested now. You file your bid.
Yes. 2 and
May-
3, sir.
Uh-huh.
Item number 2 and 3.
Ms. Neo, learned standing house irrigation department, has submitted that after the visits to the site, after the petition's visit to the site, the requisite site visit certificate has been issued. First of, in view of the above submissions made by the land council for the parties, the petition is closed. Same.
Same.
Item 3 also, sir.
Deploy.
Supplementary list, item number 18. Item 18.
Kali order.
Similar order will go, Lordship.
Huh?
Similar order will go.
You are creating litigation. Huh?
Similar.
You are manufacturing litigation. Where is the same?
My left.
No. Where is the NIT?
Let NIT, your Lordship, and is 19, my lord. But
Huh?
the pick is my lord. Is 20, my lord.
How many contract work?
Here, in this case, my lord, item number 18, only one, my lord.
Hmm?
Only one work,
Only one.
my lord.
Come to page 22. There are two.
So there is 2 packages, my lord, but petition had offered certificate for us. Only
Which
package
one?
number
Which
1.
one? Page 22. Which one?
Package number 1, my lord.
Huh?
Serial number 1, my lord. Package number 1.
Package number 1. This
Yes,
one.
Yes, yes.
Page 22.
Yes, my lord.
Hola admission. Patasar Kusi.
Yes, ma'am. That is, page 20, it is there, my lord.
Page 20 is whole.
No, my lord, it is bid documents, my lord. Q division irrigation division, my lord.
This one?
Yes. Same, my lord.
No, there are two, sir. There are two.
Yes, two package.
He's
Package, my lord. My
page 20,
application-
you are interested in page 20?
Yes, my lord. That
Okay.
is the package, my lord.
Yes, yes, yes. Page 20 is his lordship.
এনেকে angle লিখিব।
And the serial number 1 is the my lord.
There is no serial number one, only one.
Page 20, only one.
My lord.
That's all.
Yes, lordship.
Be careful.
Page 20.
এটা বিট নহয় জানো? এটা বিট page 20.
What is the date of the IFB?
Yes, my lord. Kal diya.
Date of the IFB? 6/2.
Yes, my lord.
6-2.
6/2. Page 20. A contract work on under the subject. Yate page 20 the subject ase. Chief engineer respond number?
Chief engineer,
Two.
2, my lord.
2.
My lord. And executive engineer is 3, my lord.
Clause is same.
My lord.
Clause.
Yes, my lord. Close, my lord. 6, my lord.
Page 31 একটু কোটে করে দিব। Page 31 আছে 8 করে দিছো। Clause
আমার wrong হয়। মইতো এলাও করবো বুঝতে পারি।
how many petitioner?
Then only one petition, my lord.
উঠাই দিলে কেস ফুট পালি হয়।
कौन जाना चाहिए ना इतनी तो
Plural to singular করে দিব হ্যাঁ। Any representation?
Page 86, my lord.
Huh?
86.
Date.
86.
Date.
Date, my lord, 21/2/2020.
2026.
Yes, ma'am.
What is the last date?
27.
27, my lord.
Tomorrow.
Huh?
Day after. Tomorrow.
Tomorrow?
Tomorrow. Lord. Tomorrow, second half.
It is very yes. With submission in that 5.
Oh.
It is 5/3.
Oh, Lord, sorry, Lord. It is 5,
Ah,
It is 5/3.
5-3, Lords.
Page 23, my lord.
Time আছে, problem নাই।
B2/3 না দুটো বিল আছে
হুম, হুম।
এটা সাইজ থাকবে এটা শর্ট থাকবে
কখন তো একে লেগে।
you visit tomorrow?
my lord.
এই তো কিন্তু খালি তো next case তো।
You visit tomorrow, 10:30 report. Get the certificate. We are fixing it on 2nd of March. If he does not give, then we may have to consider whether you can submit your bid without site visit certificate. Mr.
Lordship,
take a copy.
Lordship, Lordship.
Sir, my lord, last date is tomorrow, my lord.
Tomorrow.
Yes, Lord.
Another order objection.
Here, my lord, petitioner,
Where is your client?
my lord, is there, my lord.
Why he is here?
Nalbari, my lord.
Huh?
Nalbari, my lord.
Yes. He's in Nalbari itself.
Now where is the office? Which one?
This is
Executive in the Bozali,
Bozali.
same division, my lord, PU division.
No, come to NIT.
NIT, my lord. It is, my lord, petitioner had NIT lordship will file page 15, my lord.
Huh?
And 16 is the, my lord, list of package, my lord. Here petitioner had sought for site visit certificate against the package number, serial number, my lord. Package number 2, 3, 4, and 6, my lord.
2, 3.
4 and 6.
Yes, sir. তিনটা হেৰিতে যাব লগা আছিল, তিনটাতে যাব লগা আছিল এটা। এটাত যাব নে দুটাত যাব বুলি কৈছিল যে এটা পিটিশ্যনাৰ কোনোবা তাত, এইটো কালিতো নহয়, পৰহি যে এটা দিছিলো, এই যে আজিৰ যে 3 নম্বৰ আইটেম চাওঁ, 3 নম্বৰ আইটেমটো চাওঁ আজি 3 নম্বৰ। It is same with the
same division.
motion 1 to 3.
Yes, Lordship, yes. It will be same. Same, Lordship.
Okay, so 3 নম্বৰ চাওঁ, এইটো 991 2020. Earlier, this kind of clause was not there.
Lordship, in fact, in PWD department, Lordship,
It was introduced last year, my lord. In the PWD, in the roads department, my lord. Now they have already withdrawn, my lord.
they have
Some
with
great brains have worked out this so that they can exercise their
Own power, my lord.
power
To select, my lord.
to select and to reject.
আগে visit করে
visit করে job. No, কি জমা দিছে সাইড ভিজিট।
Package number
2, 3, 4, and 6, no?
2, 3, 4, and 6.
any representation?
Page 18, my lord.
Huh?
Page 18.
Date.
Date.
18 February, my lord.
Huh?
18 February.
$88.
Date is tomorrow.
That is tomorrow, Lord. Action display, admissibility होगा, कोई भी सुनो।
What is the last date of bid submission?
Tomorrow, 27, page 25, 27 to 2024 till 2.
Are you in a position to appear at 2 p.m.?
Oh,
Today, my
Ah,
oh,
yes, yes.
go there.
Lord,
You inform
Lord,
telephonic.
I will in fact already informed them, Lord.
Ah,
Lord.
tomorrow case
My-
will be
my-
listed tomorrow.
My lord, my lord.
Because 2 p.m. is the last date of submission of bills. Record you.
I am obliged.
Obliged.
Go to Twitter. The last date. Last date is tomorrow. This is last date tomorrow.
Tomorrow.
Yes, ma'am.
The other one is last date
5-3.
5-3.
5-3.
And that will be on
That is
2-3.
Lord.
This will be tomorrow.
Tomorrow. Lord.
20, item number 20.
Nalaga.
Wait, Mr. Lordship. Lordship, in this writ petition, we are challenging the terms and conditions of the tender, Lordship. Certain conditions, eligibility criteria that is mentioned in the tender, we are challenging those conditions. And the conditions are mentioned at page number 50, Lordship.
15.
50. Qualification of the bidder.
Ah.
So in this case, there are certain eligibility criteria that are given. Say, for example, eligibility criteria number 1, valid registration, water resource department.
You have it.
No, we do not have water resource department registration certificate, but we have other department certificate, Lordship.
Ah.
And paragraph number 3, eligibility criteria number 3, preference will be given to contractors who possess similar working experience to water resource management structure last 3 years. And
That is preference laws.
preference.
Preference. It is
Most-
everything being equal, then who has experience in the department or similar kind of work in the water resource department, he will be given preference.
Lord.
If all marks are same.
Lordship.
That they may have the authority.
Yes, Lord. But we are aggrieved by the condition number 11, Lordship. Next page, 51. The bidder must have minimum average annual turnover of rupees 5 crore in last 3 years, Lordship. Lordship, this number, the petitioners, Lordship, earlier, they filed another writ petition, and all the respondent authorities are same, Lordship, before the Honorable Court. And Honorable Court had order dated 18 to 2026. They actually asked the respondent authority to consider the representation. The same representation in this writ petition also. The representation is at page number 72, Lordship.
There was no pre-bid meeting.
No, Lordship.
Hmm?
No, Lordship.
In
No
the
pre-
tender document.
In the tender document is at page number 45.
Any
there's No pre-bid meeting. is
No
there.
pre-bid.
No pre-bid meeting. Last date of submission of tender documents is at page 45, 27 to 2026.
You were waiting till last date, is it not? When
Lordship,
the NIT was published, 5-2.
Lordship. Lordship, before that, we actually approached
Otherwise, these clauses, right? What is that? Rono. Okay, what is the order?
Lordship, I would like to show the order. Which challenged 3 e-tender voted by the same respondent authority, Lordship.
Representation considerable.
Representation confirmation.
Yes, Mr.
My lord,
Let them file.
my lord,
These clauses will be subject to
let the
further
executive,
examination.
yes,
Hmm.
my lord, let the executive officer consider their representation, my lord.
But they may file in the meantime bid. That is subject to outcome if the clauses are found to be arbitrary.
Apparently not.
No, so far first one is, how can you insist for, this is limiting the condition, page 50. There should be more competition,
Well,
right? If you restrict it to, say, registration of Titapur Municipal Board, then good contractor, class 1 from PWD, they will not come, they will not be eligible, right? You are restricting the competition.
well,
That is one. Next clause is okay, preference.
well.
They have experience. And if for, we will examine, but subject to limitation in examination of terms and conditions of a tender, the work is of 75 lakh.
75 lakh.
75 lakh.
And you are creating a bar of 5 crores. Right?
Well,
Heard Mr.
US Bora.
US Bora. And Mr. G. Bokolia, counsel for the petitioners.
no, for respondent number 1 and 2.
And Mr. G. Bokolial, learned junior government advocate for the respondent number 1 and 2. Full stop. The respondent number 3. 3?
3 and 4.
Three.
Municipality board.
3, comma, Titapur Municipal Board has published A is 45 notice inviting e-tender NIT dated 5/2/2026 for a contract work is 45 orders. The total estimated cost of the contract work is fixed at rupees 75.77 lakh. And the last date for submission of bids is 27/2/2026 up to 12 PM. Full stop. Petitioners are same or what?
Petitioners are same, Lordship.
Or same petition?
Same petitioner.
Okay. The 3 petitioners who are registered contractors under the Public Health Engineering Department and Titapur para 3. Para 3, huh? Clause, what are the clauses specifically?
Lordship, clause number 1, 3, and 11. Page number 50, 51.
Clause number, serial number 1,
Serial number 1.
serial number 2,
Serial number 3, Lordship.
3,
3.
and serial number
11.
11 of the eligibility criteria set forth in the instruction to bidders within bracket ITB part of the bidding document. According to petitioners, the said clauses are arbitrary and appear to be tailor-made and to limit the Constitution. By such arbitrary clauses, the petitioner are sought to be ousted from competition. The petitioners highlighting the arbitrary nature of the clauses have already submitted representation when?
Representation is at page number 72.
Date.
Date, let's see, 9/2/2026.
Okay, 9. Answer. The clauses read as under page 50th. Act number. 3 number. Aru. 11 number. The matter will require consideration. Update issue notice. Returnable on. Bocolial. Litigio Bocolia. What is the NIT date?
NIT date 5/2/2026.
Okay, returnable date.
27.
You submit your bids.
Lordship.
Let us examine. Your representation may be considered by them.
Lordship.
Similar order.
Lordship. Most obliged.
21.
Tender was called, Lordship. I participated in the tender, Lordship.
Where is the tender notice?
Tender is the first tender document is at page 34, Lordship, starting from page 32.
District Commissioner invites placing tender for transfer of footprint. The tender.
And terms of the tender starts from page 34, Lordship.
$34.
34, Lordship. And in terms of the, I have fulfilled all the terms and conditions, Lordship. And I have submitted the, as required by condition number 8, I have submitted the FSSI license. And as required by condition number 15, I have submitted the contract labor registration, contract labor license also, Lordship. But subsequently, Lordship, at page 65, Lordship.
Where is the register office document clause?
Registered office document clause, there was no clause at such, but trade license is to be submitted. And in the trade license, the office address are mentioned in the trade.
What
license.
is page 34? Bidder shall submit valid farm stroke company registration certificate.
Lordship, this is a, in terms of this condition, we have submitted, Lordship. The trade license we have submitted.
You are what? What kind of entity?
By sole proprietorship. we have submitted a trade license, Lordship. At page 48, we have annexed. Trade license from the, mentioning, in which the local address has been mentioned, Lordship, issued by the Paschim Telahi Gaon Panchayat. And also the Udyam
That
registration.
Dibrugarh rice also, they have been declared non-responsive just because their license is Dibrugarh,
Yes, Lordship.
right?
Yes,
You are Bihar,
yes, Lordship. But that condition,
at a much longer distance.
that condition was not mentioned in the earlier tender document, Lordship. That it should not be, or the state of Bihar license or other state license will not be accepted. That condition was not mentioned.
Then ultimately it has been retendered.
Retendered, Lordship.
We should notice that this stage.
Lordship, the second tender process may be state, Lordship. Second tender process.
We don't know that the second tender, only
We have
decision
an
to retender.
We have annexed. We have annexed. I have submitted my representation on 12/2, Lordship. On 13/2, the second tender notice has been published. Page 71, Lordship.
Why should we stay?
Because the
Maybe their decision is correct. Why should we should stay the transportation of NFSA rice meant for BPL category consumers?
Lordship, my point is,
Then all this will come. For passing interim order, where is that? Ronak,
Lordship,
you deposit full value of the contract.
full value is not that condition, Lordship. If that is the condition, then
What is the condition of passing interim order? Ronak International.
full
Because we, for a private interest of a contractor,
Yes,
we are not going to do, because it is transportation. Ultimately, it has cascading effect. But just because
but
equity natures justice stay at a distance.
but violations are apparent, Lordship.
No, I don't know.
Violations.
Because they have authored a document.
Yes, Lordship.
They are the best interpreter of the document. And it is not that you have been picked arbitrarily. The
Correct.
other one, just because he has license of Dibrugarh, even he has been rejected.
But the
You're having license in Bihar.
Lordship.
What is in the mind of the interpreter? If two interpretation is possible, then the interpretation adopted by the author of the document is to be adopted.
Agreed, Lordship. But
Right.
but with
So
the
I'm
same,
finding it.
Lordship, with the
We
same kind,
are not finding it.
Lordship,
Okay, you argue.
with the same
You
kind,
argue on interim.
Lordship, with the same kind of with the same document.
I can say that
we are
you,
operating.
without prejudice to your claim in the repetition,
Lordship,
right?
Lordship.
You can participate in the with the other in the second.
But I have been debarred, Lordship, because I don't have the state of
You
Assam.
can still participate. There is no bar for submission or bid
Lordship.
without prejudice. Otherwise, law is that
Then, Lordship, that
it is up to you.
may I take instruction, Lordship, for 10 minutes, Lordship? May I take the instruction?
Take your instruction.
Lordship.
Otherwise,
Or Lordship, if the petitioner is ready to
because-
deposit the money, Lordship, deposit the whole tender value, Lordship. It is 10 lakhs, Lordship.
no, crores. When such a stay order is obtained at the instance of a private party,
Lordship.
you are sole proprietor.
Yes, Lordship.
Or even at the instance of a body litigating in public interest, any interim order which stops the project from proceeding further must provide for the reimbursement of cost to the public.
Lordship.
In case ultimately the litigation started by such an individual fails, the public must be compensated both for the delay in implementation of the project and cost escalation resulting from such delay. Unless an adequate provision is made for this in the interim order, the interim order may prove counterproductive.
But,
Full cost.
but. Lord,
Full cost public, entire districts beneficiary under the BPL,
Yes.
their rights will be at stake. So I'm not inclined.
Lordship,
So I'll be deciding on interim.
Lordship,
Mala, another aspect may I
come.
point out?
Take your instruction, come,
Lordship, may I point one thing, Lordship?
whatever it may be.
The Supreme Court guideline in case of Kimberley Club Private Limited.
Okay, you give it.
May I take instructions?
NF has a rights to beneficiaries, and it is not that it has been retendered. We'll examine your case,
Lordship.
but if you turn out to be correct,
Lordship.
then this tender process is to be proceeded,
Yes, Lordship.
right?
So,
The
I'll be-
second tender process, we can make it subject to the outcome, because tomorrow is the last day.
Yes, Lordship.
We cannot stall it.
Yes. May I take the instructions?
Daily list for admission. Item number 7.
Yes, Mona, very good.
Yeah, please, Your Lordship.
Two respondents are standing on different footing,
Yes, my lord.
contrary view.
Yes, please.
Is it not?
Yes,
So one is an arm of the government, the other is an instrumentality of the state. Right?
Yes.
And law is that government must speak in one voice. Then, madam, you represent whom?
may it please your lordship. Lordship, I represent Assam Tourism, respondent
And
number 2 to
Mr.
5.
Kohli, who represent this district administration? Huh. B, D, who? B. Yes, where is he? Otherwise, it is a deadlock.
Yes, my lord.
Yes.
So, who is the person who can break the deadlock?
Lordship, already there in India affidavit, they are very clear, my lord. The entire development has been taken place with the funds provided by the central government, my lord. And now the
No, both are taking different stands.
Yes, my lord.
Right. We are not here to decide about the government's contrary stand. State is a single litigant,
Yes.
maybe through different person. One may be district commissioner, the other may be so-and-so, other may be so-and-so. But it is a state.
Yes.
For the court, state is a single litigant. That is the law.
Yes.
All these contrary stands between departments, instrumentalities of the state are to be resolved by within themselves and come out with an unified stand.
If I may submit your lordship, respondent number 9, which is the managing committee, they are the ones who is actually, is not allowing this contract to go forward. And they have never appeared in court. That is one
No, Mr.
very crucial
Gogoi
point.
is coming.
Yes. I come to you, submit.
Typically, the brief was not with me, I could not prepare it.
But,
earlier-
to cut it short,
Yes.
some Koyakujia Park
So
in Abhayapuri.
that part I
Ah.
remember, yes.
Now,
Allotted to the
Assam Tourism Development Corporation and this petitioner,
minor.
after a bidding process perhaps,
Yes.
Yes.
entered into a contract agreement.
Person.
If I am correct, then there are 12 parts or infrastructure.
13, your lordship. 13,
14.
14.
14.
Yes.
14.
Out of that 12 is
14.
handed over
Out
14,
of them, in respect of 12, there is no dispute.
My
Yes.
lord.
But the remaining two, one is what?
That
It is
parking.
parking and one is
One is
boundary
parking.
wall.
Gate collection.
And
The gate collection.
Boundary,
collection.
boundary wall. Boundary wall with gate.
two say,
Yes, I.
all one.
Yes,
ATDC say this is ours.
man.
And district authority or whatever, the committee or
There's a
something,
committee, yes.
they said this is ours,
My lord.
right?
Lordship.
And the law is that one is instrumentality of the state,
My lord.
public sector undertaking,
Law.
Assam government undertaking,
My lord.
ATDC. District administration is an arm of the government,
Lordship.
right?
My lord.
And you know, as an additional advocate general, government should have a unified stand.
Yes, I understand.
Government is a single litigant for the court. Whatever is there, you have to resolve yourself,
My lord.
right? And come up with a unified stand before the court. I think decisions are there,
Lordship. I understand.
right?
My lord.
Now, Mr. Gogoi, to resolve the dispute,
Mediation.
who is, no, you are the additional advocate general now.
Oh, they can go.
Who is the main person?
He has to resolve it.
Respond number one.
My lord.
He should file an affidavit. That's all.
Yes.
Yes.
The chief secretary. My lord.
He is the person who can resolve the dispute. His decision is final for the state government. That's all. Some committee or district subdivision officer raising issues and ATDC is raising issues, all are under him. He used to say this much, 12 is 12 or 14 is 14.
My lord.
End of the game.
Got on.
Yes.
Yes.
Oh, it can be done by respondent
done.
two also, my lord.
2, we have done it already. We have already.
They are
submitted.
coming up with contrary stand.
My lord.
The ATDC is under them.
I understand.
Their stand is same. All 14 are ours.
My lord.
Then this 8
Committee.
and 9, they are saying two things are ours and our jurisdiction.
Yes. Sir.
So who better is the person?
And without that, my lord, he's at loss, my lord.
Yes,
Already.
yes, yes. We bow down.
So you have to take up the cudgel
Lordship will say, my
to
lord.
file the affidavit
My lord.
on by the respondent number one. If whatever he says,
Then, my lord, yes.
Bow down, we bow.
Then,
down.
my
Absolutely.
both are subservient to respondent number one.
Yes,
Yes, Mr.
Yes.
completely.
To cut the long
Yes.
story short. Okay. Hard. I'll observe
My lord.
that government stand should be one.
My lord. Lordship.
Okay, please take your seat. Heard Mr. R. Rajshekhar, Rajshekhar, learned counsel for the petitioner. Mr. B. Gogoi, learned additional advocate general, Assam, assisted by Mr. G. Bokolial, learned junior government advocate, Assam, for the respondent number 1, 2,
Oh.
3.
Lordship, 2 to 5, it is Assam tourism.
Are you, no, are you standing counsel of what?
I'm the counsel for Assam tourism, 2 to 5. I'm
This is,
representing.
otherwise, 2 is government.
Department.
2 is
Commissioner.
government.
Director of
So actually, I
2, 3 and 2, 3 government.
government, my lord.
ATDC is 4 and 5.
4 and 5 then, Lordship. Actually, I given it as 2 to 5. That was my instructions.
Now, Mr. Additional Advocate General is
Yes, Your Lordship. Yes, Your Lordship.
1, 2, 3, 6, 7, 8 and 9. And Miss
P. Barwa.
P. Borua, Lion Standing Council, Assam Tourism.
Council, I'm not the standing council. There is no standing council actually, Assam tourism.
For the respondent number 4 and 5. Full stop. Para. the state government, in order to promote tourism in the state and create employment opportunities for its people, in the tourism, hospitality and allied sectors, adopted a tourism policy at encouraging investments in travel and tourism sector and allied sectors within the state. Full stop. The policy focuses on developing necessary infrastructure, development of human capital, etc., and effective policy implementation so as to create conducive ambience for travel and tourism industry in the state. Full stop. As part of the tourism policy, certain tourism properties in the state are decided for upgradation, development, operation, and management through private sector participation on lease cum development basis. And for the said purposes, the state government has appointed the Assam Tourism Development Corporation Limited, ATDCL for short, as the nodal agency for undertaking the development, upgradation, renovation, modernization, promotion, and operation and management of the tourism properties. Full stop. Para, one of the tourism properties shortlisted is quote unquote operation and management, and running of the eco park at Koya Kujia, right? Full stop. By press notice Union Bracket E dash procurement notice dated 8/6/2022. The managing director, ATDCL, invited bids for operation. I had inter alia invited bids for operation and management contract for running the eco park at Koya Kujia. Post of. But the petitioner emerged successful in the bidding process, and a letter of intent dated 28/3/2023 was issued to him under the hand of the managing director ATDCL. The petitioner was informed that his bid for running the structures, buildings constructed by the ATDCL at Eco Park at Koya Kojia had been accepted by the ATDCL, and the petitioner was asked to deposit performance security money, annual lease rent, etc. within 15 days from the receipt of the letter. according, full stop, according the petitioner completed the formalities in terms of the letter of intent dated 28/3/2023, full stop. As a result, comma, subsequently, comma, a development, comma, management and operation agreement stood executed between the ATDCL and the petitioner, wherein where the properties, full stop. The properties which are to be operated, managed and operated by the petitioner were listed in Schedule 1 of the contract agreement, page 55, 1, 2, 3, 4, 5, লিখে দিব। Para, as after the development, management and operation agreement, the petitioner wanted to take possession of all the 14 structures, building stroke infrastructures created or built by the ATDCL as mentioned in Schedule 1. Obstacles came from the respondent number 8 and 9,
8 and 9.
or additional deputy commissioner is also involved.
8 and 9, Your Lordship. SDO and the
Mr. Rajsekhar,
8 and 9.
who are the obstacle creator?
8 and 9.
8 and 9.
Okay.
8 and 9.
Obstacles came from the ends of the respondent number 8 and 9 with regard to two TWO 2. Structures, building stroke infrastructures, that is CL number parking dash 1 number,
Serial number 6 and
serial number 6, parking dash 1 number, and CL number 14, boundary wall with gate.
yes.
Full stop. Pleadings in the form of an affidavit in opposition and then affidavit in reply on behalf of the respondent number 2 to 5 have been filed. Full stop. In the said pleadings, comma, a stand has been taken by the ATDCL Limited that all the 4, they have the authority, power and authority to hand over all the 14 properties, buildings, and infrastructures at mentioned in schedule so and so at Eco Park at Koya Kujia. Koya, Eco Park at Koya Kujia. Full stop. Wherein they have stated oh, sorry, affidavit in opposition, comma, additional affidavit, an additional affidavit, and an affidavit in reply.
Yes, sir.
Yes.
Additional affidavit.
3,
Yes.
they are taking the stand, 14 is ours, all 14.
Yes. Sir.
And where the other contrary stand has been taken?
It is
In which pleading?
Respondent 6 has filed on affidavit.
Yes, madam. Respondent.
5-6.
Okay,
six
then
is fine.
contrary stand is also by respondent number 6.
Yes, madam.
It was 7 in,
6 and 7.
not only that.
Only 6 has filed.
6 has filed.
Only 6 has filed.
6, so 6 means, 6 included 6, 7, 8, 9. Right.
Yes, madam.
Contrary stand, not only it is 8 and 9 question, no? 6, 7, 8 and 9.
Probably the development committee will not come under 6, my lord, directly, my lord, in the, yes, whatever is on record that he has placed, my lord, in the affidavit of 6.
Actually, development committee has no locus.
You resolve.
Yeah.
Number 1 should resolve.
Yes.
So let us see the affidavit. 142.
143.
Page 142 onwards, Your Lord.
An affidavit in opposition on behalf of the respondent number 6 has been filed, and the stand taken in the said affidavit in opposition by the respondent number 6 would also embrace the respondent number 7 and the respondent number 8. Full stop. In the said affidavit in opposition, a stand has been taken to the effect that the infrastructure so-and-so at CL number 6 and CL number 8, 14 are to be solely within the authority and jurisdiction of the district administration. Full stop. As a result of such contrary stance, an impasse has been created, and the petitioner has projected that as a result of such impasse, he has been stopped from operating the infrastructure so-and-so at CL number so-and-so, that is, one is 6 is parking, and CL number so-and-so, 14.
14 is boundary wall with gate.
For the rights, since after the execution of the contract, when date?
Uh, 29,
20.
5, 23.
23.
29/5,
5, 23.
Yes, madam.
29/5/2023. That is more than, that is about 2 years.
More than 2 years, almost 3 years.
Okay, more than 2.5 years. More than 2.5 years. Whereas the contract period is for 5 years. Full stop. As a result, the petition has projected that as a result of such impasse, he has suffered immense loss.
Yes.
Right? You are operating the other properties?
Yes, madam.
Okay. Fair enough. From the projections made in the affidavits in the pleadings of the respondents, it perhaps emerges that they have taken contrary stance with regard to 2 properties, aforesaid 2 properties. Full stop. The district administration, which district?
Bongaigaon.
Bongaigaon, is an arm of the state government. And on the other hand, comma, the Assam Tourism Development Corporation Limited, comma, a state level public enterprise, comma, is an instrumentality of the state and is an authority under Article 12 of the Constitution of India. Full stop. For the court, the state is treated as a single litigant. Full stop. It is the state in a litigation before the court is required to come up with an unified standing. Full stop. The state government cannot speak in two voices. Full stop. The operation management, and I'm sorry, the development, comma, management and operation agreement has been executed as per the tourism policy of the state government. Full stop. If conflicting stands are taken by different departments or a department or an instrumentality and an instrumentality of the state, comma, it should be settled, it should be resolved at the state government level only in order to project a unified stand before the court. Full stop. Para. In such view of the matter, comma, it is the respondent number 1 in the present proceeding who should file an affidavit projecting the unified stand of the state government. Full stop. Mr. Gogoi, learned additional advocate general, has sought for how much time?
Sometime 3 weeks or 4 weeks.
3 weeks?
3 weeks.
Has sought for 3 weeks time to file an affidavit. I'm not saying it opposition.
Yes, I'm actually.
Affidavit
Lots
of the respondent of 5
One.
or 1.
One.
To file an affidavit on behalf of the respondent number 1. Full stop. The prayer is allowed. Place the case on.
First April.
So 1st of April,
Lots
new financial year.
Much obliged.
Yes, anything to be added?
No,
Yes.
Much. Lordship, even Assam tourism is suffering loss.
Where is the finding of the respondent 1? That will be binding to the parties.
No, that's all.
1 mile or 90.
Huh?
That will
That
be
is, Chief Secretary says that a court will hold.
the-
Court will hold that.
Masu.
Then
If Chief Secretary says,
Lordship will give it for further hearing on 1/4. It will be more convenient because again, in a new.
no, keeping parter beyond 1 month is fixing a date is difficult. That is against the notification again. 1/4.
Lordship, my
I think I have made the stand clear
yes, your lordship.
for the other court also.
Yes, your lordship. But we bow down. Lordship, a small thing. Actually, Assam tourism is also facing losses because we have not been able to collect the rent, the lease rental. We are not collecting. So
As a consequence, Ms. Borua, learned counsel for the respondent ATDCL has submitted that as a consequence, the ATDCL has also is also facing Loss of revenue.
Yes, Your Lordship.
Loss.
Much obliged, Your Lordship.
Yes,
Item 8.
I have seen that elephant preservation.
Yes.
Only section 2 has been repealed.
Right.
এই তাতে অলপ document আছে।
Preservation and
Now, what thing you have, do you think you have, you can submit?
Lordship, this section 5 says about the killing of elephant. And the members of the unregistered,
preservation
And get it, Mara.
the members of the unregistered union, they are the mahut by profession.
Right, whether they are workmen.
No, the Lordship, workmen, that is, definition is not there in the trade union act. And my understanding is that since the act is silent, as long as the any person, any association of person, those who are working in the organized sector or unorganized sector, they can form an association and they can present an application for registration invoking the relevant provision of the act. So the question of workmen here does not arise because they are working in a unorganized sector. And they are laborer, that is true. They are working under some individual, that is true.
No, yes, and what do you say regarding management?
Lordship, in unorganized sector, basically in management, word management comes when a employee is working in a organized sector, such as he may be journalist, he may be employee of any corporate sector, but a day labor, a construction worker, even then a domestic helping hand, those who are working in the different houses, they are also entitled to form their own association, that is the trade union.
Mr. Mozumdar,
Lordship.
firstly,
Yes.
don't go for such expensive submission. These workmen which you have referring to, they come specifically within the definition of workmen under the Industrial Disputes Act, right? The other one, say labor workmen in a tea plantation, the news industry is different workmen, they come under different, they get their definition from the Industrial Dispute Act,
Yes.
right?
Right.
They get their definition from Industrial Dispute Act. They come within that definition.
Lordship.
And universally they are known as workmen,
Lordship.
right?
Right.
And they are under a management,
Lordship.
most of them,
Yes.
all of them.
Yes.
Then by virtue of that, they can form a trade union, right? They comes under management is existing and workmen is the definition they get from Industrial Dispute Act. Some Industrial Dispute Act. There is a definition. There is a definition.
Workman is defined, yes.
That workman and this which you are,
I am, my submission is that I am not a employee of any organized sector. So the
now,
definition,
what is the workman in Industrial Dispute Act? Just for a moment.
most probably it is section 2.
Mr. Mozumdar, my question may be silly because I am not very accustomed to it.
Lordship.
Labor laws. A workman. There it is employed in any industry. ID Act. Or manual, unskilled, skilled, technical, operational, clerical, supervisory for hire or reward. And for the purposes of so and so in relation to the industrial dispute. So, in any industry, it is clear, employed in any industry. So, industry definition is there. Elephant thing is not an industry. right? So they get their workman definition from Industrial Dispute Act. So you cannot compare, because this, first you have to establish that this is industry. Then you can be workman under so and so. Then you can have the right to form trade union, right? Now, these provisions are otherwise, though there, that workman definition will not be applicable in Trade Union Act.
Yes.
Right. Now let us come to workman. Workman is not defined,
In the act itself.
right?
Right.
So where from you can claim or proclaim that you are a workman?
No, if I am.
Because the application, where is the application?
Application is in the.
Application clause.
Application clause is most probably section 5, Lordship. Application for registration.
Section 5.
Section 5 of the Trade Union Act.
And where is the workman part?
Workman part is exactly not defined, but
No, where it appears? Get into trade union. Trade is defined, no.
5 double A.
5?
Double A.
Every application for registration of a trade union shall be made to the registrar, shall be accompanied a copy of the rules. Trade union statement of the following particulars. Name members making the application.
In case trade union.
So from 5A and 5AA,
A.
what does it emerge? AAC, in the case of a trade union of workmen.
Trade Union of Workmen.
In the case of a trade union of workmen, so maybe it is inherent that in the case of a trade union of not workmen, whether
But-
it is essential.
But Lordship will see first, my lord, definition E. Registered trade union has been defined and the
What?
trade union has been defined.
Which one? Section 2?
Section 2E. Registered trade union means a trade union registered under this act.
That is the question they raised.
There is. And
But what is trade union?
trade union,
That is one.
It is in defined.
that is 2H. Then Lordship also read,
Means any combination, whether temporary or permanent, formed primarily for the purpose of regulating the relation between workmen. Here, it is the workmen.
then Lordship also said
And
that
employees, employers,
Between the-
or between workmen and workmen, and between employers and employers. So, three situations.
then Lordship also see the definition trade dispute. That is 2G means any dispute between employers and workmen, or between workmen and workmen, or between or non-employment or terms of employment or the conditions of labor of any person and workmen means all persons employed in trade or industry, whether or not in employment of the employer with whom the trade disputes arises.
Here comes the definition. Workman means all persons employed in trade or industry. Now, industry is out. For you, industry is out.
Yes.
It is not an industry. Khati Fondi cannot be.
Trade or industry.
What is the trade? What is trade?
Lordship, trade, although the act is silent as per the legal definition of the, in respect of the Trade Union Act, but trade means, any business. Any business that is the elephant rider. But see, the elephants are presently in Assam used for the purpose of ecotourism and religious tourism.
Mr. I don't know your trade. Trade has to be defined. Trade is not defined in
Trade,
this act. Otherwise, this industry will be industry which is in the ID Act.
no, industry, lordship, the ID Act, so far my understanding, I may
It
be
is
wrong.
not directly applicable, but industry means industry. What is industry and what is trade? The issue boils down to that. Your right to register a trade union. You have a right to register a society. That is a different issue altogether. But trade union,
This is
I have-
most importantly, lordship raised, if I go to registration of a society under Society Act, it will be a NGO. That is a non-profit making government organization, not government.
society.
And when I am going to the registered my organization under the Trade Union Act, that I am entitled to come under the Social Security Act and to get the benefit which are provided by the government to the laborer. And because I am working as an employee under certain employer that is established. A Mahut is not a owner of the elephant, so he is working under the owner of the elephant. So there is a relationship between the employee and employer. And lordship, the most one
All
that
right.
the
See, Mr. Mozumdar, I don't know. There is a speaking order, page 35. Thirty-five.
35.
These are factual determination. We cannot enter into those disputes. And according to that speaking order, only 3 is involved. Right? That is factual. Re-jurisdiction do not determine, right?
Yes, lordship is correct.
That our limitation is there.
Lordship. correct.
This is after an inquiry. This
Lordship,
inquiry cannot be challenged in writ petition.
that is also. I'm
And
not.
he has the authority, at least the register, to before registration, I think he has some authority to inquire into it, whether this
Not
should be
sure,
registered or not registered. Without going into workman definition, it emerges that only 3.
Admitting, I am also not disputing that contention,
That-
admitting, in spite of that.
That section 5, that is another matter. We are looking into your right to get registered. Without going into workman, you have only 3.
As per their report.
That cannot be entered into by this court. You can challenge that in a different proceeding, leading evidence, that is a different issue.
That was challenged before the labor court, that is the appellate court.
Labor court. Labor
That
court.
was also one of the main,
Where is the appeal memo then? See, it is
page 12 is the appeal.
page 12. Oh, no. Before the labor code,
For the labor
Ah.
code.
this one. Where is that? Let us see your memo.
It is in,
Let me read. Labor Commissioner. No, that is not challenged.
Lordship, paragraph number.
Written objection on behalf of the opposite party, the Labor Commission. Let us see. Written objection. This written objection is before whom? Okay, before the appeal. Warrant of Frankfurt.
Or reply to PROCEED. Yes, sir.
Come, Mr. Mozumdar,
Lordship.
come to page 22. This is another interesting thing.
Lordship.
This is a report, page 22. Here the opposite party begs to state that on 11th April 2022, you read further,
Yes.
right? Moniram Kulita Numal Borua Bhokolia Gor as mouth. This is one. Then,
Present working as a Mahut in the.
see, all other 104 numbers of enlisted as the members of the trade union have been working in different fields since the year 1980, especially because of the fact that in the year 1980, by notification, Government of Assam has banned this Hatipandi profession.
Hati Fandi profession.
You are what?
I am Mahut. Some of my members are also Fandi. Lordship, this, my application.
See, then ultimately it is a factual report. Three only mouths. Hati cannot be. Government banned.
No, no, that is, I am not on that.
So when it is three, then less than 7.
Yes, as per their report.
And ultimately, you have to say that this register cannot make an inquiry through labor officer Morigaon. That is not your case.
No, he can, the labor commissioner engage anyone to conduct inquiry.
So he has conducted. And ultimately, in a report, we don't have the report.
Yes,
The
report
report
is
is
there.
there, my lord.
Where is that?
Page 36.
The detailed report is there.
As per the report I will submit, I am also entitled.
Or that once it is resulted that only 3, we are not into entering into any factual thing. It is report. Read jurisdiction cannot extend to that.
The law point, Lordship.
Law point I am trying to find out. What is your law point? If the case is based on factual report, only 3 under clause.
Lordship may peruse the page 37 of the report. My page is also here.
Okay, we'll come back and read the entire report.
Lordship.
Then ultimately, if it is useless, Mr. Mazumdar, you are making me here and there. So if the report is ultimately useless, the report, if it is only conclusion, is that only 3 are mouths.
Not 3. After that report, next para E is only 1 person, my lord.
Only 1. Then, Mr. You have no case.
Lordship.
Not to speak of mouth and all, you don't have any right to get registration as a trade union.
That I will establish that as per the report I am also.
A report, which page?
It starts from page 36.
অসমীয়া ডিকশ্যনেৰীত হাতীফন্দি মানে কি? হাতীফন্দি অসমীয়া ডিকশ্যনেৰীত। whether now how this inquiry was initiated, that I can understand that from the page 36
Yes.
and 37, that Deputy Labour Commissioner, Assam, has directed the Labour Officer Morigaon to conduct the inquiry. And wherefrom the Deputy Labour Commissioner gets the power?
That is my senior friend.
Register, how he can, where is the power for the registrar to make an inquiry? Because
I think section 3,
just a minute, let me find out Hati. Or Hati. Or हो किती है और पिछड़
7, there's
Hati. Hati information. Huh?
section 7 of the Trade Union Act.
Hati. Hati.
7, 8,
7.
7, 8.
7 and 8.
What to call for? Call for. Okay. Fine. Every application for registration is need to answer by. Register may call for image for So this is a report under section 7.
No. This is not a report under section 7. Because it is under section 7 says they before cancellation or sorry before registration, if the registrar is not satisfied and if the condition of the section 4 and 5 fulfilled, then registrar may call further evidences or documents for his own satisfaction. But my case is that, Lordship, I have candidly stated in the paragraph 12 of my appeal that section 7 was not invoked in my case. Before I have fulfilled the section 4 and 5.
Then we have to find out this how the Labour Commissioner. You have to place this how Deputy Labour Commissioner has directed the Labour Officer. Because as per inquiry report submitted by the submitted application are forwarded to the office of the Labour Officer Morigaon for necessary inquiry and report. Page 35, second para. Second para.
Fact, my lord, in the writ, my lord, the labor officer, but it's a constitutional body, labor court, my lord, not made a party. Only the registrar of trade union is a party here, my lord.
State of Assam is not.
Should I make the presiding officer of the labor court as a
s-
party?
no,
Because
no.
he is exercise
No,
the,
no. Presiding officer of the labor court is not to be made a party. That is no dispute.
And
I-
state of Assam is also not there, my lord.
State of Assam may be a party, but labor of court is not a party, is not to be made a party.
That's correct.
Huh?
The registrar.
Registrar is a
my
party. Registrar who has refused it.
Trade union.
Registrar will,
commissioner.
question is whether registrar has exercised his jurisdiction correctly or not. That is one. Secondly, the order of the appellate court. Order of the appellate court. And otherwise, there is an appellate remedy
Lordship. Yes. Section 11.
where the appellate court can reappreciate the facts, evidence.
Yes.
I am sitting in 226. I cannot reappreciate
Lordship.
insufficiency or inadequacy of evidence is not a matter to be gone into by a read court.
Lordship.
If there is some evidence, that has to be, cannot go deeper into it. Now there is a report, enquiry report. And enquiry report says only 3, right?
Right.
And X says minimum 7.
Yes.
It is very easy to close it. Mr. Modunda, I am looking into it just because of in the interest of the Hati Fondi or whatever,
Lordship.
right? Otherwise, from legal perspective, it can be closed.
Lordship, may peruse the page number 38
Yes.
and close 10.
All Fondi is any. Fondi. Your Hati Fondi is not even in Hemcook,
I am, Lordship,
not in Hemcook. Your Hati Fondi is not in Hemcook, which is the Bible for Assamese language. Be that as it may.
Lordship, one more submission I may be allowed to submit. Just close 10, page 38 of the report. Any other specific view?
No, this is okay. Regularly
Yeah.
paid members of the workmen,
Yes.
but ultimately it is
Ulti-
boils down to 104 members are working in different
Lordship,
occupation.
That paragraph admits that all the members were associated with the
With the association of person,
Lordship, may peruse the section 20T, 22 of the Trade Union Act. Even then, the person who are retired from their profession, they are also entitled to form a trade union, the section 22 says,
where is the government notification, sir?
which
1980,
I don't have a copy, Lordship. Perhaps they may.
banning the occupation itself.
That-
Retirement from a banned profession,
I mean, Mahood profession is still continuing, Lordship.
only 3.
Yes, only 3. I'm admitting as per their report. They are working and others are retired as a Mahood.
No, it is after banning.
Lordship, there is some
Once it is banned, ban means ban.
catching is banned. Wild elephant catching is banned. But Mahood, those who work and still working.
No, you say Hati Fondi means catcher of elephant.
Yes, Ati Fandi, the Lordship. the word
If
Fandi.
the very word is banned, the very occupation is banned in
Lordship,
1980, I don't know. Wildlife protection, yes, wildlife protection.
My application says that out of 104 members, 70 members, their profession, they have.
No, we go by the report,
Lordship.
not by the claim. Read code does not go by the claim. Read code would go by the report of an authority who has the authority and jurisdiction to inquire into it. Right.
Then this report.
What
also
are the acts repealed?
Report says catching and carrying from different district. All right, catching is banned. Carrying is not banned.
Sir,
Lordship.
we are not entering into facts. Again, I am saying. I am trying to still find out if something is. Fondi means, you understand assemblies? Fondo jana.
Charlotte.
Solve koribo para. Dhurto. Tengor. Have you understood?
Yes, yes.
Illegal.
Wily. Crafty. The meaning is not very, what do you say? Well meaning. Dhurto. Tengor. Mr. Roy, how it is banned? That is government notification. Unorganized sector, not less than, you said 22, right? Section 22.
22.
Less than 1 hour. 22 is industry.
And also,
I no way I can reach a satisfaction that this is an industry.
and also a registered trade union.
Not less than one half.
Ah.
Is 22 is
That is a
applicable.
condition which is required to be fulfilled by a registered trade
Trade
union.
union.
No, the Lordship,
22 is not
less
in
than
your
one.
case.
This 22 is applicable in case of unorganized sector. And my submission is that I am the workman of unorganized sector.
No, Mr. Mazumdar,
Lordship.
read totally, not less than 1/2 of the total member of the office bearers
Yes,
of every, then the word is
yes.
registered trade union.
First.
Right, this is applicable for registered trade union. Then subsection 2, save as otherwise provided in subsection 1. All office bearers of a registered who is already registered. And 3, this is Council of Ministers. 22 is not applicable in your case. You are yet to be born. You are not yet born. So don't make submission on 22, please.
That is the last paragraph. Yes, it is for the purpose of the registered trade union, expressly as the act says. But I'm on the part.
No, explanation will be read with the substantive provision. You cannot pick up the explanation and make applicable to your case. It is a case, it is applicable for registered trade union. You are not yet a registered trade union. So don't waste time by taking the court to this inapplicable provision. We are trying to find out if some case is made out. You are taking me here and there. Nowhere we are reaching any destination. Right?
Lordship.
You are still in within, you have not crossed. You have not crossed section 11. Right. You have not crossed section 9. You have crossed section 7. First, you made an application, section 5, right? Then, application was considered. Then, registrar invoked his power under section 7. Then, he invoked his power under section 8 not to register, right? Then you invoke the power of appeal under section 11. And there we stop. You have not crossed beyond 11. Beyond 11, all are applicable for registered trade. So don't make submission beyond section 11. I am also reading for after so many years. Others are not applicable. Now I have seen. So far, I am sure now. All are registered. How to conduct. Is there any regulation, sir? Mr. Roy?
I don't think so, but I'll inquire from the department, my lord.
Because Assam government, I have seen, I have done my own thing, but it has not been published, gazetted. One draft industrial or trade union code has been drafted by government of Assam, right? But I tried to find out whether it has been
Published.
finally notified, but I could not. It was in 2021. And there I find, for your information, come to section 11. 11, that day we debated about A and B, right? A is applicable for withdrawal or cancellation, right? B, where the head office is situated in any area to such court, not inferior to the court of an additional or assistant judge of a principal civil court of original jurisdiction, as the appropriate government may appoint in this behalf for that area, right? Now in the draft notification, state government, Assam government has appointed the industrial tribunal as the court. But that has not been
Notified.
Gazette notification is there about draft and inviting objections and all. And thereafter they will publish the final. That was in 2021. It is a Gazette notification, right? But thereafter, it was, I'm not sure whether it is finalized.
That I'll find.
If it is finalized, then it would be very easier for this court exercising his jurisdiction that this labor code does not have the jurisdiction. So appellate order is bad and none as in law because it has exercised a jurisdiction which is not vested in him.
When I find out,
So
that too I'll find out, my lord.
find out or make some more research because I'm trying to find out Hati, otherwise, Mr. Majumdar, you have very less target, very less hole to enter. I am trying to find out whether you can have some leeway somewhere. Otherwise, even if, where is the appellate order?
Is on page number
51.
Lordship.
Starts from 50.
That starts from
53.
52.
Page 58. Page 58. First paragraph is the main reason. And second paragraph is further. Second, an additional view. Even if this is, say, not illegal, but first part remains, then there is no question of setting aside the order. This is further. This is an additional supplementary point. The main point is only three. Only three. The main point, and that is based on appellate court as well as the register based on inquiry report. So no way this court can exercise 226 power. And you have a remedy of appeal under section 11(4).
That is.
It is not perverse.
One
I'm
more-
sorry to say.
One more submission is that whether the inquiry report on the basis of what the court made of the.
Court has the power.
Yeah, no.
Register has the power. Right, wrong, no jurisdiction we
No,
exercise.
that is, my submission is that whether that has been proved or not.
Hmm?
Because the process, normally I don't know what process the labor could follow. They neither evidence, not a single witnesses were examined, neither the evidences were called.
That is appeal. It is appeal. It is not original proceeding.
And so far.
It is not original proceeding. Do you lead evidence in appeal? Have you, unless court permits?
No.
Have you laid any evidence before High Court?
No.
During appellate jurisdiction? You have done many criminal appeals?
No,
Then?
because normally.
This in 226, my power is of judicial review is limited. Yes, Mr. Roy, anything to say?
My lord.
Because this is an additional view, section 5 of the Elephant Preservation Act.
Yes.
I thought that it is the only view. Well, it is not the only view. There are two. Firstly, on the inquiry report, court has said this much.
Right.
So nothing to be interfered with. Second, further, he said section 5. Even if that is set aside, the other view remains. And other view is based on evidence. Based on evidence means based on inquiry report. And there is no question of we cannot go into insufficiency or adequacy. If the case is based on some evidence, end of the matter, read jurisdiction.
Lordship, I may be allowed to make one more submission. Subject to the approval of the court. As the section 7, as I have candidly mentioned in my appeal also in the paragraph number 12. The power to call for further particulars and to require alteration of name. The registrar may call for further information for the purpose of satisfying himself that any application complies with the provision of section 5 or that the trade union is entitled to registration under section 6 and may refuse register the trade union until such information is supplied.
Paragraph 12.
Paragraph 12 of my appeal. the appeal which was submitted before the labor. court.
Paragraph 12 of the appeal memo. Page,
Lordship. Page 12, start from page 12, the appeal. Paragraph. Page 15, paragraph 12.
page 50.
1-5.
I have seen.
That plea was taken. The appellant states that Section 7 of the Trade Union Act 1926 empowered the authority to call for further particulars and alteration of name if required. It is pertinent to be mentioned that provision of the Section 7 of the Act has not.
Mr. Mazumdar, you are repeating. Page 35, second paragraph, I have already indicated to you. Speaking order. He has gone through the proper channel, calling for particulars. Whereas as per procedure, submitted application are forwarded to the Office of the Labour Commissioner, Morrigan, for necessary inquiry and report. So he has called for particulars. Section 7 has been invoked.
Whereas as per procedure, meted application forwarded of inquiry and Mr. may call for further information for the purpose of satisfying himself that any application complies with that trade union is entitled to register under 6 and may refuse to register until such information is submitted. The information, Lordship, the act, the information from whom, from his own sources or from the applicant. The act is silent. Suppose that I have submitted application. If the registrar is not satisfied, he may ask me to submit the documents.
He can do it through proper channel, official channel. It is not that he has engaged a private detective. It is not a private detective case. He has gone through the official channel, Deputy Labour Commissioner, Labour Officer, who has gone to your office, has submitted a detailed report, made all the members of the union, which is not a trade union. It is not that the inquiry is defunct inquiry. Detailing. So, Mr. Roy, if the writ petition is dismissed,
My lord. They can apply for re-registration, my lord. They can again apply.
okay. Because we are exercising power of judicial review only. Mr. Borbuya, Mazumdar,
Lordship.
you can take a call. Let me find out.
And they have obtained certificate from Gambura, my lord. But as per Wildlife Act,
Those are, Fondi is gone. Mouth remains.
it is the chief wildlife warden commissioner who can give the certificate, my lord.
For captive elephant, if I am not wrong.
Lordship
Issue
means-
certificate to captive elephant.
Lordship means-
Certificate is owner to the elephant.
C40, my lord,
Of
Wildlife Protection Act 1972.
section to litigation, microscience.
What's the declaration?
কোডবোৰ ক'ত আছে? কোডবোৰ এটা আছে ন?
Schedule 1 at 482 code. Schedule 1. Into schedule 1. Schedule 1. This way, schedule 1.
I was trying to find out whether there was any code for trade union appeal under section 11(4). In the code, there is nothing. Maybe there is no appeal till date before Gauhati High Court under section 11.
I also don't think so, my lord. There is
Ah.
a case that very recently it was arising from the appeal. This decision is on CRP IOT 85 of
Because shall have a right to appeal to the High Court, and the High Court shall, for the purpose of such appeal, have all the powers of an appellate court under section 2 and 3. Pass an order directing the registrar to register the union. Appellate court has the power. See subsection 2. See subsection 2 of section 11. The appellate court may dismiss the appeal or pass an order directing the registrar to register the union and issue a certificate of registration under the provisions of section 9. Right? And for the purpose of an appeal under subsection to appellate court, follow the same procedure and shall have the same powers as it follows and as when trying a suit under CPC, and may direct by whom the whole or any part of the cost so and so, so and so. So it has the full power to act as a civil court. And it can direct the registrar to register the union. And there is a power under subsection 4 to prefer an appeal against a dismissal order by the appellate court. But this court is not.
I think
I am been trying for your benefit maximum time. Now I am going to pass the order. We are not referring to 11. And whether dismissal of the appeal will extinguish their right to
Under
prefer an appeal. Dismissal of the repetition, suppose, will extinguish his right to appeal, perhaps.
yes.
You cannot
Right.
choose forum
Forum.
that when
But-
the appellate remedy is available and writ petition is dismissed.
That I leave it to your lordship. Then
I don't know, he can invoke
he can apply re-registration. He can apply
two options.
with correction whatever
Ah.
he has committed mistake. He can correct it and he
Two
can.
option, he can apply for re-registration, it is up to him, or otherwise he can prefer an appeal under subsection 4 of section 11.
But whether
But
writ
so
will
far
lie
as-
or not, that whether writ will lie against the order of the labor court. So
Otherwise, labor code or it will lie, it will not
No.
lie.
to me, a maximum 227 he could have come. Supervisor's jurisdiction, my lord.
Yes, but otherwise all labor issues, power under 236 is exercised. All labor or industrial dispute dispense is 226,
Yes.
because that is quasi judicial,
Right.
not civil, totally civil.
Right.
So to civil 227, but quasi judicial or administrative authority 226, and labor court quasi judicial.
Quasi-
And that has, but Act has provided appellate remedy, second
Yeah,
appeal,
indeed. Right.
second appeal.
Either second appeal.
No, full.
Yes.
High Court has full power
Yeah,
under
full
subsequent
power.
to direct registration.
This statutory remedy.
Direct the registrar to register the union.
And that is the statutory remedy he had.
That is a statutory remedy. And this, since CPC is applicable, Section 14 of the Limitation Act will be applicable. So the time he has spent in this prosecuting the writ petition
Yes. This written
can
code
be
is superior.
allowed to be condoned by the appellate court, high court,
Within such
subsection
period,
2
anyways.
and 3. CPC follow the same procedure and have the same powers as it follows and has when trying a suit under CPC. Appellate
And
court.
Lordship, you see the operative portion of section 11. Any person aggrieved by any refusal of the registrar to register a trade union or by the withdrawal or cancellation
Second
of
part, we are not.
within such period
That means,
as may.
that means,
As may be prescribed.
Yes.
Now,
Limitation.
what is prescribed?
that means related.
Come to definition clause.
CPC.
No. Definition clause. Prescribe means prescribed by regulations made under this act.
Yes.
Now, that is why I asked for regulation. Nobody is pressing it.
That I will take the instruction at 2, my lord. I will.
Full and final next Tuesday. Now I have got hold of it. But earlier I was not familiar with trade union.
Tuesday, no?
Tuesday? আছে নেকি? কি আছে? Oh, Tuesday to
Tuesday বন্ধ আছে নাকি?
Tuesday is holiday.
Holiday.
Like Thursday to morning. Thursday will be difficult.
Or Friday, my lord.
This power. Thursday by. Thursday. Good. It was TV কৰিব লাগিব. 10th of March.
And
My
Huh? Part head. And Mr. Majumdar, take a call whether you want to avail appellate remedy or you want this writ petition to be adjudicated. Right? And third option is available to
make
make application for.
Pressure. I think that will be better for him.
Here it will be dismissed.
Lordship.
Almost. Unless you come up with a magic wand, some. Otherwise, then dismissal, whether this dismissal will affect your application for re-registration. That is for you to call. I am not concerned with that. I am concerned with only this writ petition. If your right will be extinguished, then it is your call. Where is the provision for re-registration?
I have seen section 11, the comments, section 11 down below comments, my lord, the act, Trade Union Act. Yes. Withdrawal or cancellation of registration. The order of cancellation of the registration of a trade union cannot be withdrawn or revoked by the registrar. Only remedy to go in appeal or apply for re-registration, that judgment has been referred by 8755 FLR.
Okay. Or apply for re-registration.
Right.
Rashtriya Mukund Employees Union.
Yes, yes.
Oh, this is a 2025 writ petition.
petition.
Heard Mr. FZ Majumdar, counsel for the petitioner. Mr. Jeroil and senior counsel listed by Mr.
Division.
for the respondents. So, Mr. Mozuda, earlier you came against the register order. Then
Sir,
a register order,
speaking order.
and then a repetition was said that you avail appellate repetition. Still you have an appellate remedy, statutory remedy. Release the case on 10-3 as parted. An endeavor will be made to dispose of the writ petition on the next date list.
Well, Lordship, I have a mention for another case, that item number 17, I am appearing for the petitioner, and the management advocate is appearing from Delhi. He has requested me that he has missed the flight today,
Item number?
17. Human
Okay.
left.
Huh.
So management council has requested me that he is coming from Delhi, he has missed the flight. So it may be taken in any other day,
Okay.
along with this 10th March.
MZ Modunda, learned counsel for the petitioner, has submitted that he has been informed by the learned counsel for the, he has been informed by who? Mr.
Some forgotten his name, Lordship. He's-
By the learned counsel for the respondent to make a prayer on his behalf. Right. Lakhotia.
Yes, Lakota.
Okay. Mr. A. Lakhotia, learned counsel for the respondent to make a prayer on his behalf, as he has not been able to attend the court due to personally stuff, as submitted by the learned counsel for the petitioner. List the case on. Did you put it?
Name is difficult, madam. Lakoti.
Lakhotia. We have also lack. used to be said.
Daily list, item number 10.
Your Lordship, my seniors.
Lordship, I am representing respondent number 3, that is Government
Yes.
Marketplace.
Yes.
The concerned persons, they are also appearing virtually. Lordship.
Yes, please. Who will be appearing?
Lordship, Rajesh Meena, who happens to be the director of GEM SPV. So he'll be appearing along with a list of other candidates also who expertise in different sectors.
Mhm. You are Mr. Kothari.
Lordship. Why Kothari?
How this GEM portal works? How does it function? Suppose bids are uploaded online.
Lordship.
Thereafter, there are two stages to it. One is technical bid opening. The other is financial bid opening.
Lordship.
We are concerned with technical bid opening stage, right? Now, bids are to be uploaded by the bidders along with the supporting documents.
Documents.
Then on the date and time fixed for technical bid opening,
Lordship.
the portal is to be opened,
Lordship.
right? And this is to be, whatever is open
Mhm.
is to be seen by all the bidders perhaps,
Yes.
right?
Yes.
Documents can be seen by all the
Can
bidders.
be seen. Yes.
Now, do you have the brief
Lordship, yes.
Yes. You are Mr. Rajesh. You are mute.
Your lordship, this is Rajesh Parveen.
Yes. We just want to know how the portal functions, GM portal functions.
Your lordship.
In the bidding process, this is everything is in online through GM portal.
Your
There are two stages. One is technical bid opening stage, and second is prize bid. We are concerned with the technical bid opening stage.
Your lordship.
Now, here NHIDCL was the tendering authority.
Your lordship.
It was a technical bid as per the data sheet. It was opened on a certain date, and as per the technical bid opening, which was open on which date, Mr. Bhattacharya? Huh?
22/10/2020.
22/10/2025. There were 4 bidders. Where is the page, Mr. Bhattacharya? No, there were 11 bidders.
Yes.
13 bidders.
13, total 13.
Yes, sir.
13 bidders. And after the evaluation of the technical bids, only 2 were qualified, 11 were disqualified.
Yes, lord.
So how the portal, who examines the supporting documents
Sir,
submitted by the bidder with his technical bid?
your lord, buyer examine the technical documents submitted by the bidder.
Your voice is not that
Sir,
clear.
let me. I'm
Break koriye, yes. Yes, please.
Your lordship, technical documents uploaded by bidders are being examined by the buyer.
Buyer.
Yes, lordship.
Yes. And whatever documents have been uploaded,
Yes, lordship.
can those be seen now?
Yes, lordship. Those documents which are available in our system can be accepted out, but it will take some time, sir. We can accept out, sir.
22nd October
Yes, sir.
2025.
Yes.
The bid of technical bid of Messrs. Kamakhya Travels and another one, Messrs. Sonu Enterprise.
Yes, lordship.
The technical bids of these 2 bidders
Yes, lordship.
and the supporting documents,
Yes, lordship.
which was uploaded
Yes, lordship.
at the time of technical bid submission,
Yes, lordship.
are required to be examined.
Your lordship, we can submit those documents. So please kindly give us some time to share those.
Sure. What is the reasonable period?
Sir, 1 week will be okay for us.
Huh?
1 week is okay.
1 week is
Otherwise,
okay.
Lordship, I've
Yes.
examined.
Yes.
So far as if Lordship requires on which date, which document, whether it was uploaded, that data I have. The audit log has been.
Let us
prepared.
have. You have the data.
I have it. In fact, that has been mailed also. To the,
Okay. Now,
Prima
he has the brief.
Lordship.
He has the brief.
Yes, he has
Okay.
the detailed audit log. I have the.
Okay. Can you provide us the information?
Lordship.
I'm asking him as well as you. Can you provide us the information whether which page, Mr. Bhattacharya?
Probably Lordship page
That
65.
rediscovery thing? Rediscovery.
Lordship 65 and 79, I believe.
Page
54, madam.
Page 54.
No. Yes. But I'm sorry, madam. Page.
Lordship is asking about two different annexures.
1
then-
minute, 1 minute. Let me
This
be
59,
sure.
madam. Page 59.
Hmm? Their affidavit starts at which page?
8.
NHIDCL. 1 and 2, 58.
50 onwards.
58.
59 and 69.
50 from. Their affidavit starts from
So
page 50. madam. It starts from page 50 and the opposite.
Page 7, that one undertaking, format for notarized undertaking by bidder. That is in the court file, it is at page 72.
Lordship.
Maybe at page 75 also.
Lordship, the one with stamp dated 2 September. The one with stamp, right? In our case, it's 65.
Hmm.
So Lordship, so far as this document is concerned, the audit log says that this was uploaded on 8th of September at 6:40 a.m.
8th of September,
6:40 a.m.
this document.
Lordship.
Yes, Mr. Rajesh. Mute again.
Lordship,
Yes.
we need to re-verify this thing because these data is directly available with the bidders and the buyer. So these are available also in public domain. But if we need to be examined from the system, we need some time.
Okay. So you can provide us the hard copy, downloaded copy of the technical bid of the two bidders,
Your Lordship.
along with all the supporting documents
Lordship.
Yes, Lordship.
within a week's time.
Yes.
Lordship. Otherwise, we have access. So as per their, otherwise we have access. In fact, certain documents have been mailed to the concerned court.
Yes.
But as per his, if he can get it done within 1 week, then Lordship, I don't have any embargo from my end.
You don't have any document.
Yes.
Well, let him.
No, I have documents, Lordship.
Ah.
Like based whatever time requirement they require, that is the time will be.
So you can file an affidavit
Lordship.
along with the technical bids of the two, Sonu Enterprise and
Kamakha.
Lordship.
Jamaica. That's
Lordship. Lordship.
what was the last date of technical bid submission?
22.
No. Last 12/9/2025.
12 September 2025, Lordship.
12th September. Right, Mr. Burua? 12th September?
Yes, madam. You give us the sheet. This all dates.
Dates.
Any other? I didn't like it. Yes.
Okay. Yes, Mr. Bhattacharya, that's all.
Yes.
Okay, madam. Hello, what I feel, Lordship.
On
That-
12th November
Madam.
2025, prior to bid submission closing time,
Madam.
whatever technical bid, along with the supporting documents submitted by these two bidders
Will be put.
are required to be placed on record. If this record, within this record, this undertaking is a part, right, at page 72 or 65, which was executed on 2/9/2025, right? then that they may have a tendering authority may have an inherent power to re-examine.
True, true.
Subsequent submission, that is a different issue altogether. But at the prior to bid closing time, whatever technical bids and the supporting documents they have submitted, that are to be seen only. Nothing more.
That apart, my lord, the most important part is that whether post-bid correction is allowed or not.
That is a different issue. Whether this undertaking, which was shown to have been notarized on 2/9/2025,
I understand, my lord.
was submitted with a technical bid
My lord.
by Kamakhya Traders
Fine.
and the other one Sonu,
That part I understand.
to get them included, to get their disqualified bids to be transferred to qualified category
Yes.
subsequently. That is the issue only.
Yes.
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 Right?
And more importantly, my lord, if we go by the tender document, there is not even a single recital that permits post-bid corrections. Something very clear. And more important, my lord, the logic that they have taken an example of the bid document, my lord. They said that, my lord, there is a provision in the bid document.
Oh, that is, I am saying time and again.
My lord.
Subsequent submission of document, which is stated in the affidavit of the respondent number 4, that there is no issue at all. So don't make submission on it. Right. Somebody is more enterprising to submit some more document, that you leave it to the court. After bid,
Understand. Understand.
but so that just because somebody by oversight missed a document, then one should not be penalized. But if the document is subsequent, after that 96 hours for 4 days window opening, and that has been included, then we'll come out with different proposition, right? But if it was a part of the technical bid submission, then the issue will be different.
No issue at all.
No issue there.
Part of the technical.
So we expect that GM will come up with the real facts.
Yes, Lord.
Heard Mr. S.P. Bhorasaiji, learned counsel for the petitioner. Mr. C. Borua, learned standing counsel, NHIDCL for the respondent number 1 and 2. Mr. D.K. Kothari, learned counsel for the respondent number 3. And Ms. R. Deka, learned counsel for the respondent number 4. Full stop. In reference to the order dated 23/2/2026, comma, Mr. Rajesh, your designation, please.
Sir, I am director.
Director, GM.
Yes, sir.
Director, GEM has appeared virtually to apprise this court regarding the manner of functioning stroke working of the tender processes done through government e-marketplace GEM portal. Full stop. The issue raised by the petitioner hearing that the technical bits of Messrs. Kamakhya Travels and Messrs. Sonu Enterprises, which were submitted on or before the bid submission closing time on 12/9/2025, were deficient of the essential documents and as such, comma, and were originally adjust non-responsive, full stop. Subsequently, comma, the technical bits of the said two bidders were adjusted as responsive, full stop. One of the grounds raised to assail the technical bid of Messrs. Travels,
Travel service.
Kamakya Travels, is that response number 4 bracket. It had not submitted, submitted stroke uploaded one essential document along with the technical bit. Full stop. Para. In view of such point raised, it appears necessary to look into the technical bits submitted stroke uploaded online by the said two bidders, that is Messrs. So and so and so and so, along with the supporting documents submitted stroke uploaded online before the bid submission closing time. Close stop. On a query, Mr. Kothari and Mr. Rajesh have submitted that if given a week's time, comma, the SIM can be downloaded from the GEM portal for submission before the court with a short affidavit. You simply one line, one paragraph. These are the documents. You are not into the adjudication.
Yes.
Right?
Yes.
You are only an intermediary.
Lordship.
As sought for and agreed to by the learned counsel for the parties, list the case.
Lordship, any date.
After a week?
Lordship.
Okay, what time? Yes, Mr. Boro, you have to say anything?
No.
Okay.
After 1 week, Miller fix.
9th will be all right.
9th of
Well,
March.
9. Well, 9, we are.
Let us have the affidavit. If you have,
I'll be in Shincho.
let us have the affidavit.
1.
9/3/2026.
Yeah.
The respondent number 3 shall file the affidavit in compliance of the above on or before 9/3. In compliance of the above direction on or before 9/3/2026. So let us have the affidavit
Yes, sir.
so that you can have a look, then make your submission. Right? Any interim order?
Yes.
The interim order passed shall continue till the next. Then we will understand how it functions.
Yeah, that's right.
Because all tendering process
Off
is
record-
are
off
through
record
online
and
now. It
submitting
is
will not-
GEM. So court is not having knowledge. Thank you, Mr. Rajesh.
Thank you.
So the case is fixed on 9/3. So in the meantime, you download the
Sure,
two
Lord.
technical bits and please
Sure, Lord.
forward it.
Thank you, Lord.
Due to Discord, your third party is enjoying. Because whoever is continuing, we are begging them to allow to continue.
Okay. Some
more.
doubt
Yes.
is raised, that doubt
Yes, no, that's all right.
doubt is to be
Say,
removed.
we
That's all.
will be also learning. I'll also learn.
Because respondent number 4, he is silent. That he submitted this document.
On multiple count, my lord, not only on this particular issue.
But he did not say that I submitted this
Absolutely.
document. He submitted one more document, right? And he never said in the representation, he said, let me furnish this document. But it is you who has come up with that idea, rediscovery. So that let us have the rediscovery.
No,
Discovery or rediscovery, that is all.
we'll see.
You have rediscovered, like,
We'll satisfy your lordship,
Uh-huh.
the daylight comes. We'll also try to satisfy.
There is
your
one
lordship.
important issue, my lord, whether it is discovery or invention.
ah,
It has to be taken.
invention is one, discovery is one, and rediscovery is another thing.
Important issue. Of that,
Next.
sir.
Deep care.
Supplementary list, item number 22.
Yes, madam?
Your Lordship, on the last date, I was told to produce a copy.
Yes, madam.
Produce a copy of the judgment, trial court judgment, Your Lordship.
Essential Commodities Act, Public Distribution, APDA. Yes, is there any provision in the license? If any licensee or agent. Now, what is the case here?
On the Lordship.
Yes, madam, do you have any instruction?
Lordship, this judgment, we have got through. This person was convicted in the year 2024. On the
24,
basis of allegation on which basis this is license.
FIR was lost.
Yes,
Show cause is different.
yes, Lordship.
So cause served is on different allegation,
Yes, Lordship.
right? That has been also revoked,
Yes, your
is
lordship.
it not?
Yes, your lordship.
That has been revoked and warning was given,
Yes, your lordship.
right?
Yes, your lordship.
Then
Your lordship, his shop was tagged with another shop like after that.
then that arrangement continued.
Yes, your lordship.
In partial modification, consumer, another shop with join Raj Brahma. Then you come up with
82, page 82.
page
Page 82.
page 82. Page 82, order dated.
10 July 18.
Problem is that
Yes.
all those are old things.
Yes, your lordship.
Now this has come in between conviction order.
Yes, your lordship.
You preferred appeal?
Yes, your lordship.
Any stay of suspension?
Oh, your lordship. He's on bail.
A bail there is suspension.
Yes, your lordship. We've tried contacting, but your lordship has not received any information on the appeal.
So with this development, conviction, there is two things, conviction and sentence. By bail means there is suspension of the sentence, but conviction is not stayed.
Yes.
In that case, conviction remains. And as per clause 15 of the APD order, Assam Public Distribution Articles Order,
17, your lordship.
if any licensee or his agent or servant or any other person acting on his behalf contravenes any of the terms and conditions of a license, then without prejudice to any other action that may be taken under the Essential Commodities Act, his license may be cancelled or suspended. So this, let them take decision on your license. Conviction is there.
Yes, it's a fact.
Let them take decision, licensing authority, whether they want to cancel or not. This writ petition was on a different tangent. Now this has come.
Yes, sir.
So in view of conviction, we cannot allow this petition. Right? Yes, madam.
This lordship,
And this trial court has said that this is a crime against society.
society, yes. 3 years conviction.
3 years.
Yes.
And no release under provision of Offenders Act. 409. So if your conviction is reversed, you may seek renewal of your license. The present writ petition under Article 226 of the Constitution of India is preferred. In seeking inter alia, setting aside of an order dated 22/02/2018, comma, a show cause notice dated 23/4/2018, and two other orders dated 25/6/2018 and 10/7/2018. Full stop. A a further direction has also been sought for to direct the respondents to renew the sub-wholesaler stroke retailer license of the petitioner granted under the Assam Public Distribution of Articles Order 1982. Full stop. Para. The petitioner has stated that he was granted a license bearing number KSM.35/95/46. Sorry, sub-wholesaler stroke retailer license. On 28/6/2022, or 6/12, 28/6/2012, under the Assam Public Distribution of Articles Order 1982, within bracket APDA order for short, by the licensing authority who's the one being granted the license, the petitioner carried on distribution of public distribution system, PDS, articles from his fair price shop, FPS, located at village Mokrapora, K/Bhodgaon, Peratutas, district Kokrajhar. Full stop. The license was renewed from time to time, and the last renewal was up to 31/3/2019. Full stop. Para. On 12/2/2018, one first information report, FIR, came to be lodged by one Abdul Karim Pramanik before the officer in charge, Kokrajhar Police Station, alleging that on 10/2/2018, the petitioner had illegally sold around 10 liters of kerosene from his fair price shop, and the same was detected. Full stop. The petitioner was also handed over to police. Full stop. On receipt of the FIR, The officer in charge, Kokrajhar Police Station, registered a case, Kokrajhar Police Station case number 59/2018 under Section 7, Essential Commodities Act, PC Act 1955, and initiated investigation. Full stop. The petitioner, during the course of investigation, the petitioner was arrested and subsequently, he was released on bail. Full stop. The investigation resulted into after investigation, a charge sheet under Section 173, 2 within bracket 2, Code of Criminal Procedure was laid finding a privacy case against the petitioner for committing the offenses under Section 409/419/411, Indian Penal Code. Post of. On submission of charge sheet, a charge under Section 409 IPC was framed against the petitioner by the Court of Learned Subdivisional Judicial Magistrate S. Kokrajhar in PRC case number 212/2023. Trial court. Full stop. Para. By the order dated 22/2/2018, subsequent to registration of the FIR, the respondent number 3, 4, passed an order on 22/02/2018 in reference to an inquiry report of the area officer who's by the order dated 22/2/2018, the beneficiaries, the consumers tagged with the fair price of FPS of the petitioner were transferred to another FPS stroke agent nearby in the interest of the public and for their convenience until further order. Full stop. The order dated 22/02/2018 was followed by the show cause notice dated 23/4/2018. Full stop. As per the show cause notice, an inquiry report was submitted by an inspector, Food and Civil Supplies and Consumer Affairs, Kokrajhar, on 21/2/2018. Inquiry reports were, and 20/04/2018. Full stop, page 36. From the inquiry reports, it was revealed that the petitioner failed to carry out the instruction laid down in the NFSA 2013 guidelines and the provisions of the PDS within bracket control order, 2001. Full stop. 3 allegations were made in the so-called notice with a direction to the petitioner to submit his reply within a period of 7 days therefrom. Full stop. In response to the so-called notice dated 23/4/2018, the petitioner submitted a reply on 2/5/2018, wherein the petitioner denied all the 3 allegations leveled against him in the so-called notice. Full stop. On 8/5/2018, the respondent number 4 passed an order of revocation whereby the suspension order passed earlier on 22/02/2018 was withdrawn. Full stop. In the order dated 8/5/2018, the respondent number 4 had recorded that the order of revocation was passed after perusal of the views of the inspector, food and civil supplies and consumer affairs, Pokrajar, and other relevant records. Full stop. As a result of the order of revocation dated 8/5/2018, the license granted to the petitioner under APDA order ought to have been revived, and the petitioner ought to have been permitted to operate the fair price shop for distribution of articles, PDS articles. Full stop. But by another order dated 25/6/2018, the respondent number 4 based on a report dated 19/6/2018 submitted by the inspector FCSCA, Pokrajar, and the area officer, allowed Messrs. Hodgaon Cooperative Society to distribute the allotted quota of PDS/TPDS articles against monthly allocation of the fair price shop of the petitioner till disposal of Pokrajar Police Station case number 59/2018. Full stop. Subsequently, by another order dated 10/7/2018, comma, the beneficiaries which were tagged with the fair price shop of the petitioner were transferred to the nearest fair price shop stroke licensee, comma, Mohammad Lalmia Pramanik of village Indro Colony. Full stop. It may be stated that both the petitioner and Mohammad Lalmia Pramanik as fair price shop licenses were operating under the aegis of Messrs. Hudgaon Gaon Panchayat Samabay Committee Limited, GPSS, আগতে যে কলো cooperative society. Post of the arrangement by order dated 10/7/2018 was made after the executive committee of Messrs. Hudgaon GPSS expressed the inability to continue distribution of the allotted quota of PDS/TPDS commodities in respect of the consumers of Mokrapara village due to shortfall of employees. Post of para. When the as after revocation, order of revocation dated uh 8/5/2018, the order dated 10/7/2018 was allowed to operate for the next 4 years, comma, the petitioner has preferred this writ petition, assailing the aforesaid orders, post of, and seeking the aforesaid relief. Full stop. Para, I have heard Miss Z.
K. Bhattacharya.
A. K. Bhattacharya, learned counsel for the petitioner. Mr. S. Roy, learned junior government advocate, Assam, for the respondent number 1, 3, 4, and 6, and Miss Ann Chaudhary, learned standing counsel BTC for the respondent number 2 and 4. Post of para. It has been submitted on behalf of the petitioner that since the proceeding earlier initiated by the show cause notice dated so and so came to an end with the order of revocation dated so and so, there could not have been any reason for stopping the petitioner to operate the fair price shop as the license, as the petitioner sub-wholesaler stroke APS license, a retailer license granted under the APDA order has neither been suspended nor been cancelled. So yet the beneficiaries stroke consumers tagged to his fair price shop have been transferred to another fair price shop, leaving the petitioner at large, LURCH. Full stop. Where when a query is made as regards the fate, outcome of the trial, proceeded trial of PR case number 212/2023 pending before the trial court.
PRC, Lordship. PRC case number.
PR case number I said,
Oh.
police report case. কি করলো? Don't interrupt
So-
in between. Panic. MS Authorised, learned counsel for the petitioner, has submitted that the trial has been concluded in the meantime, and the learned trial court has passed an order, a judgment and order of conviction and judgment and order dated 26/12/2024. By the judgment and by the same judgment and order, the trial court has convicted the petitioner for the offense under section 409, Indian Penal Code, and the petitioner has been sentenced to undergo simple imprisonment for a period of 3 years and to pay a fine of rupees 30,000, in default of payment of fine, to undergo simple imprisonment for a period of 9 months. So, and has placed a copy of the judgment and order dated 26/12/2024 before the court. Para on perusal of the students. It is found. On a further query, Ms. Aforesaid has submitted that an appeal has been preferred against the judgment and order dated so and so, and the appellate court, after admitting the appeal, has allowed suspension of execution of the sentence, and the petition has been granted. Petition has, and the petition has been released on bail. Ms. Aforesaid further has fairly submitted that though the period of sentence has been suspended, the conviction passed against the petitioner has not been stayed. By the appellate court. Para. Order clause 15 of the APDA order has provided that if any licensee contravenes any of the terms and conditions of the license, then without prejudice to any other action that may be taken under the Essential Commodities Act 1955, his license may be cancelled or suspended by any order in writing of the licensing authority, and an entry will be made in the license relating to such cancellation. Full stop. The order, Assam Public Distribution Articles Order 1982 is framed in exercise of the powers conferred by Section 3 of the Essential Commodities Act 1955. Full stop. As subclause 1 of clause 15 has provided that গোটেইখিনিয়ে দি দিওঁ গোটেইখিনিয়ে দি দিওঁ Para as any other order, Miss Chaudhary? What is your affidavit?
Affidavit, Lordship, before conviction, we have filed. Affidavit starts from 68.
As the petitioner has been visited with as the petitioner has been convicted under Section 409, IPC and has been sentenced in the aforesaid manner. This court in view of the subsequent development, cannot extend the relief sought for by the petitioner in this writ petition. Full stop. The petitioner has been convicted for the offense under Section 409 IPC. And even if his sentence has been suspended, the conviction is in force. Full stop. Therefore, it is for the licensing authority to take a decision and as regards the license granted to the petitioner under the APDA order in terms of clause 15 of the APDA order. First off. Therefore, the the present writ petition, the relief sought for. This court is of the considered view that the relief sought for in this writ petition cannot be extended to the petitioner. Full stop. The licensing authority shall now take a decision under clause 15 of the APDA order within a period of 1 month from today. Full stop. As this order is passed in the presence of all the sides. So you
Yes, sir.
inform if the licensing authority wants to keep the license under suspension,
Yes.
they can keep it, or if they want, they can cancel it. So I'm keeping both the option open for you. Okay. ঠিক আছে। কিবা থাকিলে add কৰি দিম।
Binding method. Item number 21.
Motion. O2. Yes.
My lord, I have taken his instruction. He's not willing to participate, Lordship.
Okay. He's placing interim order.
Yes, Lordship. Lordship,
Okay,
may I pray one thing, Lordship? It's because the prima facie violations are apparent, Lordship. So,
That I don't know.
Lordship, so
I may not agree with your prima facie view.
but this is my submission, Lordship. And can I propose one thing, Lordship? That for a particular period of time, Lordship, 1 week or 2 weeks, Lord, if your Lordship is pleased to pass an interim order, Lordship. And during that
No,
period,
beneficiaries are involved.
Lordship, that otherwise also the technical
It will be subject to outcome of the repetition.
Then I may be allowed to. I may be allowed to submit on the interim prayer, Lordship.
Please. Retender will be otherwise subject to the outcome of the repetition. And it is not that it is, or you are a sole person picked out. But there is another person picked out for contract labor license valid for Dibrugarh.
But Lord,
Right. Registered office document not submitted. I cannot make comment on it as on date unless I get the reply.
Lordship, the
FSSAI license. What is their understanding? I don't know.
FSSA Food Safety and Standard
No,
Authority.
no. What is their
Lordship.
understanding? A technical way. Yes.
Lordship, the amendments that they have brought, Lordship, otherwise also impliedly, the rejection, while rejecting the
Let us see the NIT.
NIT. It starts from page 32, Lordship.
Did you participate in the pre-bid meeting?
I don't.
Pre-bid meeting was 17/1/2000.
He participated. He participated. Lordship.
He participated.
He participated.
Did he raise this?
No, at that time, these conditions were not there, Lordship. Simply, it was mentioned that the license, Lordship, kindly peruse clause number 8. FSSI license valid up to date shall be submitted with full. And clause number 15, Lordship, the bidder should submit the up-to-date labor license issued under Contract Labor Registration and Appellation Act 1970, Lordship. And with these documents, Lordship, already he is rendering his service in other district, Lordship. And presently he is rendering his service in Bishwanath district, Lordship. All these documents were accepted by the bidding authority there.
Okay, what is your submission on interim prayer?
Interim prayer, Lordship, since these conditions, the conditions on which his bid has been rejected, Lordship, that were not the part of the original bid clause of. I'm particularly concerned with clause number 8 and 15, Lordship. And clause number 8 and 15 that were not there, Lordship. These were brought subsequently, Lordship, and your Lordship knows it very well that if the subsequent amendments are made by the bidding authority, that cannot be allowed, Lordship.
It is not okay. Okay.
And for supporting my argument, Lordship, I'm relying. This Lordship, Kimberley Club Private Limited, Lordship. Paragraph number 13 would be relevant, Lordship. Married, Lordship. Paragraph 13, it is tried that the terms of the NIT must be clear and unambiguous. The first respondent, Mandi Parishad, intended that Haysiyat Praman Patra must be issued by the district magistrate alone. It ought to have specified so in the NIT conditions. But that he should submit the FSSI license pertaining to Assam. It was not there in the original NIT condition. And the other condition, Lordship, regarding the contract labor license, that was not in the clause number 15. It was not the part of clause number 15, Lordship. And in the subsequent tender, Lordship, they have included these
And
conditions.
Binisma.
Lordship. This is pertaining to, Lordship, by imposing these conditions, they are trying to
Which
limit the
paragraph?
participations, Lordship. Limit
Which
the
paragraph? Which paragraph?
paragraph 19, 20 onwards, Lordship. May I read, Lordship? The object of
So
public.
there is a restriction under
Yes,
Article 19 within bracket 6.
Yes, Lordship. Yes, Lordship. And even in the case of Roanoke International, Lordship, it has been stated
There are many.
where
There are many that
Yes,
I
yes,
cited
yes.
one of them.
Yes, Lordship. Where the decision has been taken, bona fide and choice has been exercised on legitimate considerations and not arbitrarily. There is no reason why the court should entertain a petition under Article 226. If it is arbitrary, Lordship, your Lordship has the jurisdiction to entertain the petition, Lord. And my reiterating my submission, Lordship,
One more.
Lordship.
One private person against large number of public.
But the legal right of
you
the
address on that also.
Legal right of the petitioner, Lordship.
Yes, why should one stall a public project at the instance of one private individual, whereas the process is for large number of beneficiaries? Because you see clause 10 and 11, page 35. This is 13 number of GPSS from FCI FSD Lakhimpur. 12th number GPSS, so and so, so and so. So it is a for which district?
Lakhimpur district.
Lakhimpur district. How many beneficiaries will be?
Many, Lordship.
Many.
No, Lordship, that's why I'm submitting.
That is why.
That's why I'm submitting, Lordship.
Not even
I'm
they,
praying, Lordship.
Had
Lordship,
you approached when it was 6-2 and the rebid is 27-2.
Yes, Lordship.
Last date. That is why I said to you that, and I also allowed you time.
Yes, Lordship.
At first half, so that you can have the tentative view of the court.
That's
right.
But
A supply of one ATM machine somewhere.
Yes, Lordship.
Right. Few typewriters somewhere. 10 computers somewhere. Yes, I could have. Now my exercise of jurisdiction is more towards public interest rather than to stall. You may have a good case. It is not that you may not have a good case. You might have a good case. Right.
That's it.
But at this stage, I'm not stalling.
That's why I'm, with all respect, Lordship, I'm praying again, Lordship, if the interim order can be permitted for a particular period of time, Lordship, 10 days or 14 days. Otherwise also, the technical bid will be open today. For financial bid opening, there would be a intervening period, Lordship. During that period, the Lordship can decide the matter finally, Lordship.
It is not possible to decide. That is the problem with such backlog.
Lordship, otherwise the legal right of the petitioner is also required to be
legal right with all these persons which are against you, beneficiaries.
Lordship.
Heard.
No, Lordship, otherwise taking
you have another forum.
But taking the principle laid down in Roanoke International, Lordship, the officers can exercise this kind of errors or arbitrary action.
No,
Lordship.
you might have a good case.
Lordship.
I'm not saying that.
Lordship.
It is not that view of the code.
Lordship.
You could have a can have a good case.
That's it.
Right? The point of rejection. But court is not only concerned with the petitioner's grievance only.
That's it.
If you see paragraph 12 of Jagdish Mandal,
Yes.
then you go to the civil court, ask for damage.
Yes. That's it.
Right?
That's it.
And the two questions.
Yes. That's it.
We have to see two questions.
Okay.
Paragraph 22. What are the questions? Public interest, second
Yes,
question. So there is no public element for me to stay.
That's it.
But had it been delayed, the next retender notice, I could have said, but you have brought to the notice of the court that tomorrow is the last day.
That's it.
We cannot solve.
So I humbly pray that my interim order.
I have heard. I'll record so that you can
No,
have an
okay.
option. Two options. And Mr. Z. Bokolial, learned counsel for learned junior government advocate for the response number. All. Full stop. All the respondents. Para. Page 32. By a notice inviting tender NIT for selection stroke appointment of handling and transport contractor for transportation of food grains under NFSA-2013 of Lakhimpur district, comma, the respondent number
Respondent
3 invited e-tender stroke bids for transportation of food grains. Full stop. As per the NIT, comma, the name of the work, contract work is, what I say, first box 2. And the specification of the work is, the period of the work is for the is during the financial year 2026-2027. Full stop. Para, as per the schedule of tender, comma, a pre-bid meeting was scheduled on 17/1/2016 and bid submission start date was 14/1/2026. Full stop. The bid, the closing date, the last date of bid submission was 4/2/2026. And the technical bid opening date was 5/2/2026. Full stop. Para. The petitioner has stated that he had submitted, it had submitted, the petitioner, comma, a proprietorship firm, comma, had submitted all the requisite documents listed in the bid document, along with his bid. Full stop. After opening of the technical bids on 5/2/2026, comma, the technical bid evaluation committee evaluated the technical bids of the 6 participant bidders, including the petitioner. Full stop. Upon evaluation of the bids, comma, the committee declared 2 of the bids as technically qualified and the remaining 4 bids as technically disqualified due to non-submission of the documents mentioned therein. In the minutes of the meeting, recorded on 6/2/2026. Full stop. The committee had further observed that as per Rule 23 within bracket 16 of the Assam Public Procurement Rules, 2020, if the number of bidders qualified in the technical bid evaluation stage sorry, no, 2020, number of bidders qualified in the technical bid should not generally be less than 3 to elicit fair comparison of bids. Full stop. On that ground, the committee decided to process for retender within a time duration of 12 days from the tender of publication of the notice, considering the upcoming election urgency, and to ensure fair competition and transparent appointment of contractors. Full stop. After such decision, a fresh tender notice, a fresh NIT has been published on 11/2/2016, and the last date of submission of bids in response to the NIT dated 11/2/2026 is 27/2/2026. Full stop. The technical bid opening date has been fixed on 27/2/2026. Full stop. Para. I have heard Mr. Das, learned counsel for the petitioner, has submitted that the reasons for disqualification of the technical bid of the petitioner are clearly illegal and arbitrary. Full stop. The petitioner has submitted that in respect of a similar nature of contract for another district, namely Bishwanath, the petitioner had submitted the same documents to support his claim of eligibility stroke qualification to carry out the contract of same nature, and the petitioner, having emerged successful, was granted the contract, and thereafter the petitioner is currently operating. Full stop. As the ground of rejection of the petitioner, ground for disqualification of the technical bid of the petitioner are clearly arbitrary and illegal, the impugned decision for disqualifying the bid of the technical bid of the petitioner is liable to be set aside. And if the technical bid of the petitioner is adjudged as responsive, then there will be 3 participants at the technical bid opening stage, and the subsequent NIT dated 11/2/2026 needs to be recalled. Full stop. It is his submission that the technical bid evaluation committee had added more conditions than clause 8 and clause 15 of the bid document. Full stop. Para. Mr. In support of his submissions, Mr. Das has referred to the decision in Kimberley Club Private Limited versus Krishi Utpadon Mandi Porishod and other 2025 INSC 1276 and Vinisha Technologies Private Limited versus State of Chhattisgarh and another 2025 INSC 1182. Par contra, Mr. Bokolia, learned junior government advocate appearing for the respondents, has submitted that since the respondent number 3 is the tendering authority and the author of the bid document, it is the interpretation. The Constitutional Court should defer to the understanding and interpretation given to the terms and conditions of the bid document by the author of the document. If two interpretations are possible, then it is the interpretation which is adopted by the tendering authority is to be respected. He has further submitted that the acceptance of the bid of the petitioner on the basis of the documents in another contract by another tendering authority cannot be a cause to criticize the decision of the tendering authority in another contract work. The tendering authority in the case in hand is independent of the tendering authority in the other similar contract work. The matter would require consideration, issue notice returnable on so and so. As Mr. Bokolial has appeared, accepted notice for all. No formal notice, extra copies by tomorrow. Heard the learned counsel for the petitioner parties. Also on the interim prayer. Full stop. The reason for disqualification mentioned by the technical bid evaluation committee. Reason for disqualifying the technical bid of the petition, mentioned by the technical bid evaluation committee, R, page 65, 1, 2, 3. In clause 8. Of the bidding document, it was provided that the bidder should have a valid trade license, inter alia, a valid trade license, and FSSAI license. Valid up to date. And the same were to be submitted with the bid. Full stop. Clause 15 has prescribed for submission of an up-to-date labor license issued under contract labor within bracket labor registration and abolition bracket close Act 1970. Full stop. On perusal of the minutes of the meeting of the technical bid evaluation committee, it can be noticed that the technical bid evaluation committee, it transpires that had adopted a strict approach to the terms and conditions of the bid document. Full stop. While the bid evaluation committee, technical bid evaluation committee, has not accepted the license submitted by the petitioner under Contract Labor Act, for short করে দিব, as it was for the Bihar state. The committee has also not accepted technical bid of another bidder on the ground that his contract labor license is valid for Dibrugarh only. Full stop. Similarly, likewise, not similar, one of the ground for disqualifying the bid of the petitioner is, quote unquote, registered office document not submitted, unquote. Full stop. On similar ground, the bid of another bidder লিখি দিবেন VIZ Nisika Road Lines Nagaon has been disqualified. Full stop. Another ground of rejection, disqualification of the technical bid of the petitioner is, quote unquote, quote কৰাই আছে. The third ground is that the FSSAI license is for the state of Bihar only. Full stop. Para. The contract is meant for lifting and transportation of approximately 48,000 quintals of PMZKAY rice each month under NFSA-13 for Tier -1 from the nearest FCI Godam and the transportation from the FCI Godams in the district of Lakhimpur are to be made to about 31 Gaon Panchayat Samabay committees, who in turn would make the PMZKAY rice available to the beneficiaries in the nooks and corners of Lakhimpur village or Lakhimpur district. Full stop. The number of beneficiaries within the population of it is not difficult to envisage that the number of beneficiaries under the PMZKAY rice within the population of Lakhimpur district are large, and timely delivery of PMZKAY rice to the beneficiaries, which are from the socially and economically disadvantaged population, is of paramount importance. Full stop. While considering the private right or legal right of the petitioner, a constitutional court cannot be oblivious of the public interest and public elements involved in a tender process. Full stop. This model quotas. আছে. It has been held in Jagdish Mandal versus State of Orissa and others reported in 2007 14 SSC 517 that the power of judicial review is not to be permitted to be invoked to protect private interest at the cost of public interest. Full stop. A tenderer or contractor with a grievance can always seek damage in a civil court. Full stop. When the matter of disqualification of the petitioner's technical bid is looked from the standpoint of public element stroke public interest involved. This court is our primacy view that it is the public interest which should prevail over the public private interest. Full stop. It is also settled. It is also a settled proposition that a mere disagreement with the decision-making process or the decision of the administrative authority is no reason for a constitutional court to interfere. Full stop. The owner or employer of a contract having authored the tender bid documents is the best person to understand and appreciate its requirement and interpret its documents. Full stop. The Constitutional Court must defer to this understanding and appreciation of the tender documents, unless there is malafide or perversity in the understanding or appreciation or in the application of the terms of the tender conditions. Full stop. It is possible that the owner or employer of a contract may give an interpretation to the tender documents that is not acceptable to the constitutional courts, but that by itself is not a reason for interfering with the interpretation given. Afcon Infrastructure Limited. Full stop. Para. The decision in Bhimisa Technologies Private Limited has interpreted the reasonable restriction within the meaning of Article 19 within brackets 6 of the Constitution of India. Full stop. It is in Kimberley Club Private Limited, Supra. It has been held that the terms of an NIT must be clear and unambiguous. Full stop. The tendering authority while laying down the terms and conditions of the tender condition, must specify the condition in clear terms in the NIT itself. Full stop. Para, having considered all the aspects for considered the submissions of the learned counsel for the parties and the materials on record, comma, this court, no লাগে তারা কথা লিখো, it is apposite to refer to the following observation made in Ronak International Limited, paragraph 10. Para. The first tender has already been published on 11 to 2026, and the last date of submission of which submission is 27 to 2026. Full stop. From the NIT dated, from Annexer A, Annexer B, Annexer C, and Annexer D to the NIT dated, NIT dated 11 to 2026. It is demonstrated, it is evident that PMZKAY rice stroke food grains are to be transported under NFSA to the nooks and corners of Lakhimpur district. First of, having regard to the public interest and public element involved, this court is of the considered view that the no interim order staying the bidding process initiated by the NIT is primacy view, dated 11 to 2026 is called for at this stage. First of all, the matter of rejection, matter of disqualification of the technical bid of the petitioner in a bidding process initiated pursuant to the NIT dated so and so would, however, be subject to the outcome of the writ petition. I have made the option open for you.
That's, I'm grateful. That's
2703.
You will get it, if not today, by tomorrow, 10:30.
That's. I'm blessed.
For us, I don't know if you
11. Yes. Oh, that. Yes, can be corrected.
We have no objection.
Huh?
We have no objection.
Heard Mr. R. Dubey. So, learned counsel for the petitioner. It will be a typographical or review or what?
typo.
Typo?
I made a submission to effect, my lord, that there is a civil suit pending, title suit 685 of 2024.
Let us have it.
My-
Where is the order?
At paragraph 9, your lordship would see page 16 of the I.
And Mr.
Akhtar.
R.
Akhtar.
Akhtar, learned counsel on behalf of Mr. S. Somoria, learned standing counsel, UCO Bank for the opposite parties. For the opposite party number 1 and 2. Where is Mr. Bokolial? Mr. G. Bokolial, learned junior government advocate, Assam. SS Roy, learned junior government advocate, Assam, for the opposite party number 3, 4, and 5. Post of. This interlocutory application is preferred by the applicant seeking typographical, seeking correction of a typographical error in an occurred, kept in an order dated 12/2/2025, passed in a writ petition WPC number 164/2025. Post of. The applicant herein was the respondent number 4 in the writ petition WPC number 164/2025. Post of para. In the writ petition, comma, the opposite party number 1 and 2, as the writ petitioners sought for a direction under section 14 of the Act in respect of a property comma, mentioned in detail in the order dated 12/2/2025, full stop, para. In the paragraph 9 of the order dated 12/2/2025, reads as under, quote করে দিব. Para, Mr. Dubey, learned counsel paying for the applicant has submitted that instead of no, comma, it should have been A. And he had made his submission accordingly. Full stop. Mr. So-and-so, learned counsel appearing on behalf of Mr. Somoria, has submitted, comma, on instruction, comma, the word, quote unquote, no, is a typographical error. And he has no objection if the typographical error is corrected by replacing no with A. Full stop. Whereas as the learned counsel parties have submitted that the our learned counsel for the parties are in agreement that the submissions were made as regards pendency of a litigation in respect of the sixth floor of the property before the civil court, and the word no is a typographical error, comma, the instant interlocutory application stands allowed. Full stop. Meaning thereby, comma, for all intents and purposes, comma, no, meaning thereby, not again, meaning thereby, comma, the word quote unquote no is to be replaced by quote unquote a, and is to be read as quote unquote a for all intents and purposes, and this order is to be treated as part and parcel of the order dated 12/2/2025 passed in WPC number suite. If none, anything to be added?
No, that's deeply understood.
The interlocutory application is hence allowed to the extent indicated above. Dhorna, yes.
Connected to the
Did you file any pleading? You said something would be filed?
Lordship,
In fact, they have filed new petitions.
Sorry, Lordship,
Oh,
for
yes.
subsequent development and the same.
So what do you think? This are to be typed along with that?
Yes, yes, Lordship.
And if pleadings are exchanged in the meantime, next day we'll hear all the four?
Yes.
Agreed?
Yes.
How many? Ms. Choudhury?
Yes.
Okay. The contract is for what? 2 years.
2 years and
If you succeed, remaining period you will run.
Lordship, I am instructed that NRL has issued work order only for
Right?
2 months, Lordship.
2 months. So you wait. If you succeed, you'll run for the remaining period. So let us have it when?
Other matters are fixed on 13th of March.
So no new pleading. Because you submitted.
Yes, other.
Okay. Heard Miss M. Bora, learned counsel of the petitioner in WPC number, I go to Likidiva, Miss B. Choudhury in WPC number 6412. Mr.
M. Gogol.
M. Gogoi.
For number 2.
And Mr. S.S. Roy.
1.
S.S. Roy, Junior Government Advocate or Central
Union
Government
of
Council.
Union of
Central Government Council for the respondent number 1, Union of India, and Mr. M. Gogoi, learned counsel for the respondent number 2, Numaligarh Refinery Limited. Most of learned counsel for the parties have conjointly submitted that 2 other petitions, involving similar issues, are ordered to be listed on
13th of March, Lordship.
13th March. 13.3. And these 2 petitions are may be listed on 13/3/2026. So stop the praise allowed. List these 2 cases on 13/3/2025. So stop. The learned counsel for the parties have submitted that they would make an endeavor to complete the pleadings in all the writ petitions before 13/3/2020. File your response.
Obliged.
Correction.
Page correction will be in 2.
I heard Mr. R.J. Das, learned counsel for the applicant, writ petitioner, and Mr. Bora, learned standing
GDT and
GMC for the opposite party number 1 to 5. Post stop. The applicant herein is the writ petitioner in the accompanying writ petition WPC number 880/2026. Post stop. When the writ petition was moved on 17/2/2026, this court had issued notice. Any interim order also?
Yes,
Okay.
interim order was also.
While issuing notice, passed an interim order on 17/2/2026. Full stop. The instant interlocutory application is preferred, seeking certain correction in paragraph 4 and paragraph 10 of the order dated. In the order dated 17/2/2026, the paragraph paragraph 4 and paragraph 10 read as under para. The learned counsel for the parties, comma, like R, comma, in unison, comma. In paragraph 4, the date of the review meeting ought to have been recorded as 13/2/2026 instead of 13/12/2026. Full stop. And further, comma, as the private respondents are arrayed as respondent number 7 to 8, 6 to 8, comma, in paragraph 10, the words, quote unquote, the respondent number 6-7, unquote, ought to have been the respondent number 6-8 at the 3 places.
Yes.
Right?
Yes.
The corrections, the aforesaid corrections sought for in this, by this application are allowed accordingly, comma, in paragraph 4. Instead of 13/12/2026, comma, it should be read as 13/2/2026. Full stop. Similarly, in paragraph 10, instead of quote unquote, the respondent number 6-7, unquote, are to be read as the respondent number 6-8 at the 3 places wherein the words have occurred. This order is to be treated as part and parcel of the order dated 17/2/2026 for all intents and purposes.
Deeply obliged.
The instant interlocutory application stands allowed to the extent indicated. Itu sama itu. Itu next to gimana?
All hearing.
Yes, you are waiting for much. Item, which item you are waiting for?
For hearing whether lordship at the time would permit it.
Not possible. If a hearing will not be possible,
Maybe.
some other things. This item 14.
Will have 14.
Item 14.
Hearing matter.
1 minute. Mr. Thakur, you could have informed me at 10:30 a.m. only. Right? See the cause list. See the cause list. Had I been in that side, I would have appeared against you. My name is reflected
I see.
as your opposite party counsel.
Oh, oh,
So you wasted your time
yes,
till 4 o'clock.
maybe.
Please the case before any other way without me.
Sorry.
I did not see the cause list.
Oh, I said that it may be a middle studio or somewhat, it's difficult for me. At this stage.
You would have been free by 10:30. You could have sent your junior.
What to do? Hey. It's in my.
Anyway, it is good to see you
So,
after such a long period of time. Okay. Any other matter, Mr. Kaushik?
Hello.
What kind of case is this?
Here, my lord, we are challenging a leasing out of a public pond as a commercial fishing. The government says that it is a pond which is under the fishery department. We claim, my lord, this is a public pond mill. And they claim that it has been notified as a, but there is no notification as per.
Let us leave it for some other day.
Yes.
Right. Mr. Bokolial, who is appearing? Bokolial. Give the file. File you at a date. Thaka hearing or did you? File election from at a date of 26/03 or April already. I have. B. Kaushik Learned Counsel for the petitioner, Mr. G. Bokolial Learned Counsel, Junior Government Advocate for the state.
yes.
Respondents are present. Full stop. Okay. Interim order. Okay.
Yes.
You are enjoying? That's sought for an agreed to by Learned Counsel for the parties. Lease the case on dash interim order. Passed earlier shall continue till the next date of listing.
7. Grateful.
Hey, please, you not.
You were there.
No. For the other case, Lordship.
Which one?
Lordship, actually, in regard to item number 17,
In the morning it has been informed.
actually, I told him the other side, but I was not there and he had some other case maybe in the list. So after doing that case, he mentioned. But the only thing is that he has fixed a date wherein Mr. Lakhotia is not available again. Then again, I have to seek adjournment. So
It
maybe
is
for change of the date, Lordship.
already up.
I have told him over phone that I will be addressing you,
So
Lordship.
upload, we will say. All are uploaded already.
No, Lordship, I have checked. It has not been uploaded as it.
In the system already, I have signed and uploaded. Hello, pretty low. If you examine the kiosk, you will find it there.
I have checked, Lordship.
Already I have signed by 1:10. I have signed.
I have checked, Lordship.
Make a prayer, and then I cannot change now. Already signed order.
Only the date, Lordship, and
No, this cannot be done. Make a prayer on that day. Come up with that. I don't know. Mr. Mojumdar has said that he has been informed. Then I tried to find out the name. Then we find that he is Mr. Lakhotia.
yes.
Right?
Yes.
From the other orders. Then I recorded his submission. Tell him not to come. You make a prayer on that day.
Deeply obliged.